You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. The Supreme Court of the state of Florida is now in session. All who have cause to please draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is in re amendments to the Florida Rules of Criminal Procedure.
Good morning. If it pleases the court, I have to say it's been a while since I've said that. Feel like the Dalmatian, the old fire dog, brought out to play as a lawyer again, but appreciate the opportunity to work on this matter. It's something that I've had interest in for a long time. I'm Jimmy Hankinson. I'm a circuit judge here in the Second Judicial Circuit. Was pleased to be the chairman of the subcommittee, the post-conviction subcommittee that worked on drafting these rules, working along with Judge Emus, who sat on our subcommittee and then was the chair of the steering committee that helped draft these proposed rules. I'm going to take a little time because I think it's important to talk about the process. I think the deliberative process that we went through is important for consideration. So if you'll bear with me just a few minutes, and I'm sorry it takes me a little longer to say things than some people, but one of the comments from one of the responders was we need to study this. I think that's why I think maybe we need to look at it historically. This has really been going on since 2005. In June 2005, then Chief Justice Perriente formed the Post-Conviction Rules Work Group, which was a committee formed from the district and the circuit court performance and accountability committees. In September 2006, they issued a report. Many of the things that they said in that report are encompassed by what we've done in our proposed rules. Their major findings were to delete 3.170L, delete 3.800A, separate 3.850 claims between judgment and sentence issues, create a committee to work on the rules and forms, so we had updated forms and rules as we went along, and provide adequate staffing for the courts to deal with the large number of post-conviction matters we had. That was in September 2006.
I wanted to ask you just a question about that.
Certainly.
I appreciate it. Is one of the hallmarks to me of that report, and I see Judge Emis was on that committee, so we're all growing old together, you know, with these, is that it contemplated extensive forms to assist litigants in the courts in processing these post-conviction proceedings. Since being on the appellate level for 18 years, you know, there's just so many handwritten multi-page motions. Is that a part of what you contemplate? Because it seems to me for this to work where we can simplify the process, avoid repetitive filings, promote justice as well as expediency and efficiency, that part is a critical aspect.
We absolutely agree. And we started in our process was to start drafting some forms, and then we said, well, that doesn't make much sense because we're not sure how the rule's going to end up when we get through, and the forms really need to be crafted to follow the rule. So we actually drafted some orders, and we drafted some motions, and then we discussed it, and we said that really doesn't work because we don't know where we're going to end up. We strongly urge this court to come up with some procedure, in some form, and I don't have a perfect answer for you exactly how to do it.
But you want it, that's something that you would contemplate would be
absolutely,
part of it.
And you know, something along the lines of the family law forms that we have.
Except not as many of them.
Well, not as many, but they do need to be crafted. There are different 3.850 issues, and the one motion doesn't do it all.
But if we don't have the cooperation of the Department of Corrections to be able to have this done electronically and filed electronically, we're not really going to get that efficiency. And I had one other question about this. I noticed that the filings in the circuit court for 2008, 2009, it's part of, I think, of
Post-Conviction Rules
one
Work
of the
Group.
things that was presented at a conference. There was such a disparity between certain circuits. Like the 17th had 5,800 filings in 1 year of these motions, whereas the Second Circuit, your circuit, had 364. You know, was there any looking at? I guess it's trying to say what is underneath it, which is sometimes a deficient sentence or another problem. Is there anything that you looked at to prevent the motion from being filed, for example, jail credit? You know, we looked years ago, I asked, could we do a sentencing form? So and then I want you to continue on this, but did you look at, before these motions get filed, how we can have a better sentence that might prevent the need to file a a post-conviction or anything like that.
We didn't really approach it from that standpoint. Okay. I mean, we had a lot to deal with.
No,
frankly.
and you did, and your committee has done to me a great job.
We were under a timeline that we were trying to abide by. We came pretty close to abiding by our timeline with a minor extension, but we did have to limit it to some extent. So we didn't really look into how to prevent it, other than to have rules that everyone understood what the guidelines are and the criteria, and I think that's part of the problem.
Judge Hankerson,
yes.
One of the issues that concerns me the most is your proposed elimination of Rule 3.800A, and I know that the proposals all sort of work together, and it would be a part of 3850 now.
Right.
But tell me exactly how an illegal sentence would work under 3.850. I mean, do you end up with the 2-year time limitation for filing a motion involving an illegal sentence, whereas under 3800A, you could have filed that at any time?
Right. The answer is yes. And one of the things that I've tried to do in drafting, and I mean as a collective, we've tried to do away with the term illegal sentence. I hope you don't find the term illegal sentence in our rule anywhere, because it's just proven to be an undefinable term.
Isn't it still a statute, though?
There is a statute that doesn't dovetail exactly with what we've done. There is a statute that says sentences in excess of the statutory maximum can be appealed at any time. Of course, frankly, I think this court long ago in the Johnson case decided that time limits are for this court to decide, not for the legislature. But yes, there is a statute. But what we thought was just a huge waste of judicial resources trying to decide what is an illegal sentence or what is not an illegal sentence. One of the first things I did was assign one of our members to go and give us a definition of illegal sentence. I asked Mr. Fingerhut to give us a workable definition of illegal sentence based on the case law we have up to this point in time. That was one of our initial things. He came back and said, I can't do it. I can't come up with a workable definition that everybody can understand of exactly what an illegal sentence is under our current law.
What you can have is a list of particular errors that have been determined to be illegal sentences.
Right, but it's a moving target.
But isn't that...
It seems like it's all boiled down to now an illegal sentence is only one that exceeds the statutory maximum?
No. That's what the statute says. No, the illegal sentence could be any claim they want to raise as their sentence. And there hadn't been a lot of discussion of it. This isn't all one way. Under what I envision, under 3.850B and under the jail credit rule, we're actually probably giving them more hearings than currently exist. They're going to be able to get a hearing as to their sentencing claim. Which at this point, the way it works, essentially, there is no evidentiary hearing. I know this court recently has ruled on the jail credit issues that it couldn't be determined from the record. You can almost never determine a jail credit issue from the face of the record. They're going to get a hearing on that. What we are doing is saying, but they're going to have to bring their claims and us have that hearing within a reasonable period of time.
But you do have the word, instead of a legal sentence, we now have prejudicial error.
Right.
And isn't that just putting a new term in to decide what now prejudicial error is?
Right.
I mean, I guess that you have listed certain things that would constitute errors.
Right.
So why couldn't we just say they're sentencing errors and these are the ones? Because if you're and is the intent to limit the time that they can bring those?
Absolutely.
Well, any claim, any sentencing error has to be brought when?
Within 2 years of the conviction, the sentence becoming final.
You see, I guess what I had thought, and this is a tough job that you had, that we have any time now, and that any time seems a little too long. 2 years this would be from the date of the sentence is final. 2 years to me for something that somebody is serving too long in prison is too short. I had thought maybe we would try to take what's the worst thing that we've corrected that really will change a sentence and give those the longest time, 5 years, whatever, it could be 5 years, or because they're so rare, but don't close the door.
Right, but they're not rare in the filings. That's the problem. These prisoners, with every exception, we get a torrent, I guess, of filings to fit that exception. Now, a lawyer wouldn't file that motion because he knows it's frivolous.
So is the problem that prisoners continue to file multiple 3-800 motions?
Absolutely.
And so if you put it under 3.850, you're limiting them to one motion.
Right.
Is that what the problem you supposedly is fixing?
Well, there are two problems. One is I'm currently, as a circuit judge, dealing with 3.800, sometimes as to jail credit from cases 1984, 1982. Why are we dealing with foolishness, truthfully, from 1984 and 1982? Now, you say, well, that should be easy to deal with. They're not always easy to deal with.
Do you ever find jail credit problems in the sentence? From the ones that are...
how can I know? From 1984, they say I was arrested in Dade County and spent 3 weeks in jail that I wasn't given credit for. There's no way I can ever decipher that and determine whether that's true or not.
Yeah, well, that's why I think that if we can't, jail's credit needs to be solved at sentencing.
Right,
and
absolutely.
Then, that's one, I think the idea of a time limit there. But
it never fit well into the 3.800A because it's not of the record anyway. I'm sorry. Did somebody say? Did I answer your question, Justice Perriente?
You're limiting the time.
Let me kind of figure, I'm sorry. We could probably spend a day discussing this, and we spent days and days discussing this, which was going on with the process we've been through. In June 2007, Chief Justice Lewis at the time asked the steering committee to go back and look at 3.850 and 3.851. It was part of the problem. There were some meetings occurred, and really nothing much came out of that until in September 2009, the Belated Criminal Appeals Joint Committee then submitted some changes to this court, which y'all have recently adopted. Many of those kind of dovetailed into recommendations that we had already made, so we went back to the drawing board and tried to, see what was the same with us. And then in July 2001, our subcommittee was set up and the steering committee was reinstituted. We started meeting then. We had 7 formal meetings. We started out with 4 circuit judges, and we ended up with 3 when Judge Emis defected to the appellate court. Then we ended up from 3 to 4 district court judges. We had a defense attorney, a prosecutor, and an assistant AG, and a DOC lawyer. And we worked through the process, and what we tried to do, different than some committee, we tried to reach a consensus that everybody agreed with. It came down to there were very few issues that we didn't work around to where something that everybody could agree with. The illegal sentence exception was one that we had we didn't end up with unanimous vote on that. That was one of the few issues. But by and large, we came up with a package that everyone agreed with. The problem, and I think it's kind of been stated here, but to put it in a little more concrete terms, the post-conviction work group had given us some stats, and I wish I had better statistics, but as you all know, statistics are a little hard to pin down sometimes. But according to their report, in 1988, there were 1,000 appellate filings on post-conviction matters, and in 2005, there were 6,000. Trial court filings from 87 to 88, there were 2,500 3.850 motions filed. To when 03, 04, there were 12,000. Our prison population in June of 88 was 34,000. June of 2004 was about 82,000, and today we have about 102,000. So we have about, I'm not great math, but about 24% increase even since they looked at it in 2004. And I suspect if we had good figures on post-conviction filings, the numbers would follow that. We tried to consider three things: fairness, finality, and resources.
Judge Hankinson,
yes, sir.
A great amount of the moving force with regard to the need for attention to the post-conviction proceedings developed from the district courts of appeal believing that a great many of the matters could and should be resolved really before they even get to a full-blown appeal at the district court level. And my question is directed toward the composition of the committee and the vetting of this with the district court, with the appellate judges conference, and whether the input there, because it seems as though the proposals are going to limit some of the things that were installed certainly at the not necessarily insistence, but with the favor of the district courts. Have we vetted that sufficiently?
As it turned out, we had more district court judges than we had circuit judges on the committee.
Well, again, have we vetted that, though, with the conference so that we have a consistent view on those?
No, we, as I say, we had 4 district court judges on our subcommittee, representation in the steering committee. It was vetted with the appellate rules committee. I don't know of any vehicle to try to do it with the conferences, either the district or the circuit. I don't really think they're set up to give us meaningful input.
Well, they certainly give us input when we pass the rules. So, to me, I think that's because that's what I have felt for the last 14 years is the pushing of the district court judges that this is an area where they are just totally overwhelmed, and that they felt that we really needed more opportunities for those claims to be resolved at the lower level. Yet it appears what's going to happen now is those are going to be restricted somewhat. And I'm just wondering, what the relationship and how these are going to work together as it has in the past.
I think they feel, at least the appellate judges were working with, very comfortable. I mean, Judge Altenburn was the drafter of the post-conviction rules work group. I mean, he was the main drafter of that, and a lot of what we've done is consistent with what he drafted then, and he was on this subcommittee along with 3 other district court judges. I think their feeling is what we need are some rules that we have clear understanding of, which I think we do, and that was basically the committee's determination that 3.850A is working pretty well as to convictions. We have a process. Everybody kind of understands what the process is. We kind of grumbled over the Spira, case for a while, but I think we've adapted to that, and we've incorporated those into rules. So we give the litigants a chance to state their claim, and we give them multiple chances to state their claim. And eventually, if they've stated a decent claim, we give them an evidentiary hearing. And that's kind of what the rule. I don't think, and they didn't view, and I guess Judge Emas will speak for himself on that, that I don't think we're dumping work on the appellate courts, if that's your sense. That was not their sense.
A lot of the goal of this, as I understand it, is to bring about finality and to eliminate frivolous claims.
Absolutely, absolutely. Let me talk real quick. I think I'm into Judge Enos's time.
Actually, I'm not deducting this from his time. So he's gonna but if you could sum up in a couple of minutes.
I wanted to talk about the concurrent jurisdiction issue because we got to split this up, and he's not going to be prepared to do that. Could you put the poster up there for me? Just if I could real quickly sum up on that, because I think there's some misunderstanding of that, and I wanted to just talk about it. I'm not a great abstract thinker, but to kind of put it in concrete terms, I think you got this handout. I don't know that anybody can read the poster. I certainly can't. But anyway, just to kind of put it in concrete terms, what we were talking about is the goal is that if there's a problem with the conviction, to go ahead and put it so that the litigant has to go ahead and contest that. This Breland case, there was nothing particularly significant about this legally. It just happened to be the one I looked at the docket, and this was not that I went through and looked for a worst case scenario. This is the only case I looked at. But you look at a case where an arrest in 2004, he pled guilty in April of 2004, and today it's still ongoing as to the finality of his conviction, where under what we proposed, if his first appeal did not involve the conviction and only involved the sentence, he would have had to have filed any 3.850 as to the conviction by December 2007. If the first appeal did involve the conviction, he would have had to have filed any attack on the judgment by March 2009. I'm just trying to put it in somewhat concrete terms what we're talking about. There are some pros and cons. That may cause some confusion. But I think when you add it all up, there certainly is some confusion in the law now.
So would it mean that the public defender who is whoever's representing the defendant on appeal on the sentencing issue would then have to tell the defendant to file pro se his post-conviction motion on the judgment while or whatever?
He would have to tell him that his time's running if they only apply.
I mean, it would be contemplated that would be filed pro se while the appeal is still going on just on the sentencing issue.
Right.
And are there a lot? I mean, I guess in terms of that dual kind of thing, are there a lot of those cases?
I don't think there are a lot of cases where they don't appeal everything the first time. But what you do get, you get resentencing cases. And, there are a fair number of those where the appellate court first time through says there's a problem with the sentence. The conviction is fine, but the sentence, there's a problem. And the way it currently is, you keep going until the next appeal from that resentencing matter to get anything finalized. The other situation, which is a very common situation and is not addressed by the rule, is the defendant who's put on probation. He may be put on probation for 4 years, violates his probation, eventually gets sent to prison. Can he go back and contest the conviction that he originally pled to? Now, I know there's a district court opinion that says he cannot, but nothing in the rule prohibits him from going back and contesting the original plea, and that might be 5 or 6 years later after he's violated his probation. So, I mean, I think those are the two scenarios. And I think, the rule of law should be that the trial court can't do anything that affects the appellate court's ability to make a ruling. And that's basically a rule of law. The first DCA is stated. The second DCA is stated. This court is stated. I don't think it's going to cause the confusion that everybody envisions, and I think the main goal is to get the convictions to a situation where they're finalized. I've eaten up a lot of time, and
we thank you.
I appreciate it.
May it please the Court, Kevin Emus, Chair of the Criminal Court Steering Committee. In order to keep the court on pace if it wishes. I could simply reserve 5 minutes for rebuttal.
Are you going to address some of the substantive issues?
Well, I know that the court is obviously concerned about the narrowing of 3800.
I'm also, yeah, and also the taking B, and which was to be something that could be done right close in time.
Correct.
And it seems like that's being rewritten.
We are narrowing the grounds under 3800B.
I guess the question is, if you were us, what would be the biggest thing that we could do that would help with fairness, finality, and resources, and not, screw up the law? I mean, the law that is currently seems like some of it is in a state of like a legal sentence. We've talked about it, but we sort of have I think there's enough people that know what it is and what it isn't, but now we're going to have prejudicial error. And then, or how are we going to define that? So is there anything that you would say this is the most important thing we could do?
I think the most important thing that we can do is to provide for finality. Finality of a sentence. Because right now, the truth of the matter is, for the trial courts and for the appellate courts, as long as there is an unlimited period of time for a defendant to attack the legality of a sentence and to claim that a sentence is, quote, illegal, we will never have finality. As we indicated in the joint petition, it's the square peg in a round hole
I guess the problem
strategy.
is we get these original petitions, and there's nothing all the time. And we dismiss them on the authority of Baker, or on this. It doesn't stop anyone from filing them. You still have to look at them.
The problem is that's true.
How does that eliminate, if a prisoner has no, you've put the nail on the head here, the prison population and the sentences are the cause of this. We can't, that's certainly understandable, but you're not going to stop prisoners from filing things.
It's true. I don't think we'll ever actually stop pro se petitioners, but if what we can do is limit, and slowly I think we are, and the overall intent here was to restore 3800 to its original purpose, which was to correct errors that could not have been preserved and corrected during the imposition of the sentence or the written sentencing order which followed. That was the original purpose of 3800, and of 3800B. We've attempted to restore that original purpose, to catch those errors that occur in the course of the sentencing itself or in the subsequent sentencing order, and allow those issues to be corrected either before appeal or during the window period on appeal. 3850, by contrast, has a time limitation. There is a time bar. But as long as you have an illegal sentence that can be corrected at any time, prisoners will always attempt to formulate their claim, which should be under 3850 and barred. It will be formulated as an illegal sentence to overcome that time bar. And as long as we have those two ends of the spectrum, the time bar under 3850, the unlimited time period under illegal sentences, clear 3850 claims and muddled 3850 claims will always be filed under 3800 to avoid that bar.
Could we not then define, because what you're saying is that there's a misuse of 3800. I don't know if we break down in the circuit court filings which are which, that's the...
We don't.
Yeah,
we don't
and
dig
so we
that
don't
deep.
know out of the 5,800 in Broward County.
And by the time it gets to you all, it's pretty clear that these claims are without merit. But the amount of time and resources and energy that is devoted both by the trial court and the appellate court to determine that this is not truly a sentencing.
It's not, we don't know because this is not electronic. Oftentimes, if this person is filing in 3 different places, which is why, again, I'm going to urge the Department of Corrections to look at this with us to see that we can get this electronically. We can then identify who keeps on filing, because what if the person of all these people actually has an illegal sentence? That's what I'm worried about.
And that's, of course, what all of us are worried about, the subcommittee and the steering committee as well. That one case out there where someone is sentenced to 30 years on a third-degree felony, it's clear that it's an illegal sentence, and he spent 12 years in prison before he discovers it. And obviously, there are methods under the existing rules and even under our proposed rules which would allow that. Presumably, it should have been raised at the trial court at the time of sentencing.
What method would that be? Because as I read what is being proposed, that after the 2-year period, how would you do that?
Well, ultimately, under 3850, the writ of habeas corpus for manifest injustice would allow the correction of that clearly undoubtable illegal sentence.
So explain to me then in 3800B, which you are proposing amendments to, one of the proposals seems to be that now the state has an opportunity to rule under 3800. What is the limitation on the state? I mean, does it have to be something that the trial judge mandatorily had to do, or can the state
what we've said in
appeal
3800B,
what they believe to be other sentencing
no,
errors?
specifically what we indicated is the state has a right to file a motion to correct an error where the court failed to impose a statutorily mandated minimum sentence. So if it's a minimum mandatory that was required to be imposed,
that's it.
There's actually three things that the state can do. The second is and the state only has 15 days within which to file that motion to correct that sentencing error to impose a minimum mandatory. The second is a scrivener's error, incorrect name, incorrect date. The third is an error, the correction of which benefits the defendant. So the state has the right, not sure that it would be used that often, but can file a motion to correct a sentencing error.
So a scrivener's error would not be that it should be 15 years, no, and it actually says 10 years. That's not a scrivener's error.
That is not a scrivener's error.
Let me go back to something I was going to ask you. On this 3800A and saying there should be time limits for where you're trying to get around things, but did you look at whether there could be 2 or 3 specific types of errors, whether it's habitual offender, something that doesn't require evidentiary hearing, it's not jail credit, that would have an impact on the sentence, that we ought to at least raise to 5 years or 10 years, that just because we've seen that those things happen, but require that unless it specifies that and give, that's it. And if we have a form that accompanies it, as I thought Judge Altenburg had originally said, you could be sort of working with that form, so if there's something that has been added that we didn't...
Just add it to the list.
It's just there, so we don't have to go through 5 appellate courts figuring out, is this manifest injustice?
Well, Your Honor, in Maddox v. State, did an exhaustive review of sentencing errors which are deemed fundamental and presumably would fall into that category of illegal sentences, but which could be raised as fundamental even on direct appeal. This rule would not change that. To the extent that there are sentencing errors that occur that fall outside of 3800B, if they are fundamental, for example, improper habitualization, departure sentences without giving written reasons, the very things that you wrote in Maddox.
But we said, I thought in the rule it says, this is not, doesn't apply to fundamental error, which, and I understand that because prisoners use...
We did not mean to eliminate fundamental error. We did not. The intent of these rules...
Well, except that what prisoners do is they say something and then they just say it's fundamental error as if it's going to get around the time bar.
Yes.
I mean, I've got a lot of understanding of how difficult it is for the trial judges, for the appellate judges, and for the system, and I again appreciate this. The other question I had is on 3800B. It seems that although we had some issues as to whether they're evidentiary issues, we were trying to get that corrected at its earliest opportunity. Is that remaining, or has that been eliminated? The idea that
to correct it as soon as possible.
Yes.
Well, we narrowed those categories, but yes, the idea is to correct them.
It's narrowed to what? Only
It's narrowed to 3 specific categories. The failure to include a required condition, such as a minimum mandatory.
So that's for the state.
A term that's in conflict, the written sentence is in conflict with the oral pronouncement, which is under existing law. We don't intend to change that. Or an error that is conclusively revealed on the face of the record. So those are the three express
I guess
categories.
I didn't, we've had a lot of those cases. I didn't see that
What does that mean?
rule was creating more work than it was worth for the trial judges? Is that the, is that the problem?
Well, I think that and 3800B was moving away from its original purpose to
Well, only
capture
because
those
some
errors that
people
occur.
didn't, some appellate courts seemed to, or somebody seemed to think it was going to be anything in the sentencing process. But we've clarified that, haven't we?
Well,
That it's only sentencing, an error that affects the sentence, not any error in the sentencing
procedure.
process.
But even that has still been subject to some argument. And we thought this made it clearer, though it did narrow. It did require trial counsel to preserve it in the trial court, raise
But
it
then
during the
it
sentencing.
gives a chance, and Mr. Ufferman had a case where you could file it and bring it to the judge's attention. Now you've preserved it, so you don't have to deal with the issue whether it was preserved.
But presumably the incentive would be for them now to deal with it at the time of the sentencing, to prepare properly for the sentencing.
Assuming we don't have overworked public defenders
fair point.
and strain resources
Your Honor.
there.
Fair point, Your Honor. If I may save just a minute or two for rebuttal, I thank the Court.
Good morning. May it please the Court. My name is Andrew Stanton. I'm here today on behalf of the Florida Public Defender Association. If I may, I'd like to address the changes to Rule 3800, and Mr. Miller will be talking more about 3850. The Rule 1 was adopted to preserve the justice guaranteed by the rate writ and to make it more efficient. The question, I think, at a very base level here is, how do we know how do we know what changes are needed? We have no data.
You see, but the problem, and again, I understand this, but the public defenders don't get involved with what the courts get involved with because the prisoners are pro se.
Many of them, yes.
So, I mean, I would say the best thing the public defenders around the state could do is have in each office one sentencing specialist that would be there at the time of sentencing, so that if poor young public defender that doesn't know the sentencing law, make sure that sentence is imposed correctly, so we wouldn't have this. I mean, honestly, from a resource point of view, that would be, but, my sense has always been the public, whether they plead out or whatever, we'll worry about the sentence later.
Well, we don't even see the sentence until later. But
well, that's another problem. It should be, and again, I think that if we could work to get the sentence imposed on the day that the written sentence, on the day it's pronounced, and then it be somebody that makes sure and go over the checklist to make sure it's correct, we could, and I guess the question I have on that is that ever something that the Public Defenders Association would be willing to work with, the court on to try to bring integrity back to the sentencing process?
of course we would. And, the court has been asking since 1996, or at least that was the first time I was hearing it, that, we can fix a lot of these problems by having simultaneous sentencing orders. Here we are, and we still don't have them, so we still need a process to deal with all this. What I was getting at with the statistics is we don't know what the big problem is because we don't have numbers. We have anecdotal experience from the people who are doing, but we don't know. Are 3800Bs really what's clogging up the courts? Do we need to so restrict it because it's such a problem?
I would refer you to, we do have, the court every year collects information. It's right now, as of the last time, it's 25% of the workload of some appellate courts are appeals and post-conviction cases. We know that the filings are, at least 2008, 2009, were 17,000. Is it the major issue? The problem is that it is an inordinate use of resources because they're handwritten, because and there's no, we've lost law clerks, so there's a big yes, it's a big resource issue. Trust you know.
I'm not saying it is. I'm saying we don't know which resources are really the problem. We don't know, is it 3800A the problem, 3800B, what is causing us problem, because we don't have any figures.
Let's assume we know that we see motions filed years later, I look back, 1996 conviction, 1986 conviction. They just keeps on being filed. Let's assume that that is a continuous problem. How do we fix it?
It's going to continue to be.
How do we fix it?
Under the proposed rules, you haven't fixed it either. For instance, say 3800A, well, if there's a truly troubling sentence, well, we're going to create a new standard to resolve that, and you can file a writ. But that's not going to stop people from filing the writ. That's not going to stop people from saying, well, okay, there's no 3800A, so I can't say it's an illegal sentence.
Well, let's get to something even more basic. I mean, if what is the public defender's position on the fact that the proposal is to eliminate 3800A, which is the illegal sentence provision, put it under 3.850B, I believe it is, and have it done as any other 3.850 motion. And so what's wrong with that? What do you think is the real problem in changing and putting it under that provision?
The real problem is what was pointed to, I think, even by the petitioners, that there will be cases of injustice that must be dealt with at any time. And the category we have settled on are the things that you can look at the file and know, here is injustice. Here is an illegal sentence. And this court has said time and time again.
They argue that you can then do that under a habeas petition.
Right. And what I'm suggesting is that the reason we have post-conviction rules at all is to channel and make more efficient the habeas petition while preserving it. And it's going to be a step backwards if we say, well, we won't even have a rule for that. What we'll do is let you work it out on a petition. And let me suggest that if we ever do get to the point where prisoners have forms and have access to electronic filing, it's going to be a lot more efficient if they also have forms for an actual recognized rule to file.
So you would agree that with this idea that forms will help the process?
I think it will be very helpful. Nothing is going to solve everything.
Here's the problem with 3800A now. It's not even expressed as a motion. It says a court may at any time correct an illegal sentence.
I agree. In our comments, we say that it could certainly benefit from being a more detailed rule.
The other problem is that there's no provision for an evidentiary hearing. And I'll give you a classic case. There's, I think in Bover, there's a series of cases where, the question is, are these sequential?
Right.
So you don't know, were they imposed on the same day or different days. It needs to be fleshed out, but as Judge Hankinson says, it should be, why should that go 20 years later? Wouldn't we benefit from an encouraging, whether it's, what's wrong with the 2 years? Would you say if it was 5 years for some things it would be okay? But having a time limit, because the guy sitting in prison and 30 years later realizes he has a life sentence that he should have gotten 5 more days, because he was in jail. I mean, really, that doesn't warrant putting everything in that category. So that's where I'm on both sides of this, because I want to make sure that justice is served and that there isn't a manifest injustice. But the system is really, I think, it is broken, and it has been broken. So where is the compromise? If we said it was 3 years for sentences or 4 years, would that be better? I don't
think it's going to change it. We can have time limits for different kinds of claims, and the drawing line between things where you need to find facts and things where you don't is a very sensible one.
So you like that. So if it's a factual thing, you like the idea of 2 years.
And the work group actually proposed, let's forget about a legal sentence. Can you fix it by looking at the file? Yes, we'll fix it. No, we won't. So you don't have to worry about what the definition of an illegal sentence is. 300A is an important safety valve for justice. Will people file inappropriate 300As? Yes. Will they file inappropriate writs otherwise? Yes. It's something that, unfortunately, the system has to deal with. And the one set of numbers we really have is that the prison population has grown, and it's grown a lot faster than the court system's resources. And unfortunately, now the question is, well, can we now further contract access to justice because we're stuck with the legislature won't give us enough money to do it the way we've been doing it.
What's the position of the public defenders on the elimination of L from 3.170, motion to withdraw the plea after sentencing?
Well, as we say in our comments, the biggest problem it's going to present is, well, two things, a problem of simple justice and a problem of law. The court in Robinson says you have to be able to preserve a issue that you can raise on an appeal through a motion to withdraw plea. Now, if you take that, at the time, there was no specific, there was no 170L. The court later created one to cover that Robinson provision. But you take away 170L, what are you left with? The court said in Robinson you have to be able to do it. So what are we going to do now? And I think that you may actually have a chance later in the calendar to talk about the kind of situation where injustice will truly be worked if you can't, after sentencing, file 170L. And I just, without going into it too far, I'd remind the court of Justice Cantero's position in Partlow as a potential future revision that would provide a more workable solution, that you don't have the right to withdraw turn on the happenstance of whether or not sentencing is imposed at the time of the plea or sometime later. On 3800B, first, I want to submit that it is very unlikely that that's clogging the court system. They're filed by attorneys, so hopefully not frivolous pleadings. They are very focused, and they are meant to promote the efficiency of the appeals process as well as the trial court process. And when I look at 3800B, my biggest concern is the burden shifting, which the committee says in its response, yeah, this will shift the burden onto the defendant to establish prejudicial error conclusively from the face of the record. And for instance, in the example of a score sheet error, the committee says, yes, you would have to use what was the 3800A standard of could have imposed, absent the error. So in the case of a preserved error, you would have would have imposed. In the case of a 3800B, you'd have could have imposed. You come back on a 3850, well, now it's would have imposed again. And if there were still a 3800A, then we'd be back to could have. The problem with 3800B is the contraction beyond Jackson, but also the attempt to shift the burden to defendants when it was supposed to be a way of hopefully correcting but preserving the error before you go up on appeal. Now, preserved error is subject to a standard we all know. It's harmless error. But if we turn it into a duty of the defendant to establish conclusively prejudicial error, well, you have, in fact, shifted the burden. In fact, that's what happened initially when we did the Criminal Appeals Reform Act litigation. The question was, can the legislature say you have the burden of proving prejudicial error? And the court said no, and Goodwin said you can't do that. And that's what's happening right here if you adopt 3800B as written.
So that's, and that, as you say, those are motions that generally are filed by the the lawyer representing yes. the defendant. How many, in Miami, you're from Miami,
yes.
Are sentences, written sentences, almost always entered after
yes.
the actual sentence?
Yes.
Always?
Yes. As is the written judgment, which leads to sometimes the judgment doesn't conform to the pronouncement.
What? Why?
I don't know what the clerk and court resource. I mean, we've been trying to promote this, and in the county courts in particular, the pilot programs to try and make these things all happen at once, and probation orders.
Because that would help you significantly. I mean, that alone might eliminate most 3800Bs.
Well, a lot of them, and the court has recognized that, well, in some situations it takes a certain amount of expertise to spot it.
What about the jail credit one? That seems like a reasonable idea of if someone's got jail credit, they ought to, especially if they're on short sentences, there's no reason to want to wait years. I mean, if they're entitled to it, they should get it. And if they're not, let's put it to rest. Isn't that a good rule?
No, because I try to answer the
Did you like anything? No.
I did, and I like where we were headed, but sadly, my time is best used being critical. The attempt to move jail credit errors into a separate post-conviction motion, I find troubling because they specifically strike it from 3800B. Now, I would submit that the easiest and most efficient place to deal with the jail credit issue is when the attorney says, aha, the credit wasn't given, that you go back to the court and say, hello, I'm a lawyer, please give them the credit. Instead, we're going to have a system where at some point after the appeal, it would appear, unrepresented defendant comes up with his 3801 rule and then says, okay, now please give me my credit. Maybe the time is already run by then on what would have been the credit. And then, of course, we can have a writ. Then we come to, well, maybe you can keep it in 3800. And what are we left with when we have 3801 and 3850? You have a question of how much more complex we want to make the rules.
We really should have probably, I don't know, a numbering, maybe just one post-conviction rule and just have subsections.
And I've got no brief for keeping the numbering the way it is. If you want to move 3800A into 3850, fine, but you need to keep the essential provision that a truly illegal sentence can be convicted at any time. And just briefly to touch on, there is a law, a statute, that's in the way of saying you can't convict an illegal sentence at any time. And it's suggested by the committee that perhaps that is unconstitutional. I would just question whether or not the time and the place to make that determination is in a rulemaking procedure without any briefing on the question whatsoever. As to the 3170, well, I just want to return to another point. The petitioners have pointed out that when we have criticisms of the proposal, we're pointing to cases that we're interpreting the old rules. And that is true, but I would point the court to its own cases. For instance, 3800A, the court is not simply saying, well, let's read this rule 3800A, and what does it require? No, it is turning to a principle of justice. And the court has spoken pretty strongly. In Carter, for instance, it said that there's the goal of ensuring that defendants do not serve any sentence contrary to law. In Maddox, we spoke of the utmost importance of correcting this category of sentences. If it's of utmost importance, I don't think that it changes once you change the rule, and I think it teaches that you need to still be able to capture those rules of utmost importance. And at this time, unless there's more questions, I'll pass my time on to Mr. Miller.
May it please the court, I'm Seth Miller, and I'm here representing the Innocence Project of Florida. I'll be discussing...
If you could just keep your voice up so we can hear you.
I'm sorry, Justice. Again, Seth Miller from the Innocence Project of Florida. I'll be discussing changes to Rule 3850 as they relate to challenges to convictions and issues related to finality.
Let's start with the bifurcation, it seems, of the conviction and the sentence into two different subsections of 3.800. Are you opposed to that?
We would be opposed to that.
Why?
There's a few reasons. First of all, let's just take the situation that we saw on the chart. Imagine if you have a conviction that is affirmed on appeal and a sentence that goes back. We'd like to start, or the proponents would like to start, the point of finality from the time that mandate issues affirming that conviction. You have 2 years to file a 3850 from that point. There's a first problem with that, is that many of the claims that require that you file in a 3850 claims, Brady claims, Giglio claims, important constitutional claims that you can't raise earlier and often don't avail themselves until post-conviction, require public records to raise those claims. And if you look at Chapter 119 of the Public Records Laws, they say that there's an exemption to disclosure of those public records from either the police agency or the prosecuting agency when the case is active. And the case is active when there's a pending prosecution or pending appeal. And now you're going to have an evidence custodian, not a lawyer, at the evidence holding agency or the record holding agency that's going to look at the docket, and they're going to see that, wow, the sentence is back in the circuit court, or maybe it's on the appellate court. And
or you could have two different 3.85 vote motions at different times.
You could certainly have two different 3.85 vote motions at different times. I mean, it creates sort of separate problems. It can confuse litigants in one way. For example, in the situation I was discussing, they may not know that they have 2 years from that moment when the conviction, in the proponent's view, becomes final. They're going to wait until the end of when the sentence becomes final.
Well, that would be the law. I mean, we had to deal with this, and it was never changed when there was an attempt to do a tool track on death cases, and we pointed out at that time that unless the and that was for cases that were just going on direct appeal, that unless the exemption was changed, this couldn't work, and it hasn't happened. But so I appreciate what you're saying. On the other hand, because you're here for the Innocence Project, which means that you want to protect people that are innocent. Now, if in the case of Mr. Breland, who had his sentence, he pled guilty, he was sentenced to 20 years in 2006, if he were innocent of the charge, do you really want him to wait until 2012? I mean, isn't there an advantage for the person that truly has some claims, or that the conviction is flawed because counsel was ineffective? The longer you take from the time that the offense occurred, if it's the memories fade. So there is some, I don't know how often this happens, this type of situation. But, there is something to be said about the advantages to a defendant who is not only maybe not innocent, but entitled to a new trial on post-conviction. So wouldn't there be, what about that interest?
Well, certainly, Your Honor, there's obviously someone who's innocent, or even if they're not innocent but have viable constitutional claims that would entitle them to a new trial, would want to file at the earliest possible time, and we certainly agree that that's the case. But again, they have to be able to file. If they have certain claims that need those public records, their ability could be frustrated in the situation that we've seen here. And they
so you're saying we would have to, the legislature would have to make a change.
The legislature, Your Honor, would have to act. They'd have to change the definition of what an active criminal investigation is in order to make this even possible. I mean, and there's some other problems with this dual tracking. When you have, so let's take the situation we have. You have a conviction that becomes, or a conviction that's affirmed, and a mandate issues, but the sentence is reversed and goes back. So again, this person, they're thinking that their sentence is not final yet. It's not time to file a 3850. The person who's unknowing in prison is not trained in the law could potentially default their 3850 to the conviction issues simply because they're relying on what is now the current state of the law. In addition, the courts could certainly be confused, and obviously they can be trained through the appellate courts reversing and things like that. But courts, the way they view that second motion, should they file the 3850 related to conviction? I mean, if it's, let's say, denied with prejudice on the merits, when they file that second motion related to the sentencing, the question is, how does the court deal with that? Are they going to deal with it as the proponents say and say, oh, well, it's titled motion for relief from sentence, or are they going to view it and say, well, this is untimely because we're counting the point of finality from when the conviction was affirmed when mandate issued, or are they going to say it's a successive motion? Now, the proponents have taken out that language in the successive motion provision that says, it's not successive if unless there's been a denial on the merits previously. Now they're going to look at this and say any previously motion filed means that this is successive. So it can create confusion. Now, obviously, it can take time to train, but the question is, the amount of years that it may take for this to filter out through the system and fix a lot of these problems is the kind of efficiency that I think the proponents hope we get going to outweigh people falling through the cracks. And that's at the Innocence Project. That's what we're concerned about, is people falling through the cracks, people who have viable claims because they're innocent or have good constitutional claims that would entitle them to a new trial. Are they going to be, in this new regime, are they going to be shut out? This new regime, I think, we've talked about forms and methods to help prisoners get to a facially sufficient motion so it can be dealt with on the merits once and for all, and those things are important. We'd absolutely support those. But I think we've sort of gone the other way with these provisions. The other thing that I wanted to talk about with these provisions is this concept of importing, SPIRA, what this court did in SPIRA, into the 2-year time limit for raising claims from conviction and sentence when that becomes final. Now, this court dealt with a completely different situation in SPIRA. In SPIRA, you all suggested that in situations where you file a timely but facially insufficient motion, and for whatever reason, maybe because the court is slow, it's denied outside of the 2-year time limit, at that point, you get 30, as Justice Cantera, 30 days suggested in SPIRA for leave to amend so you can cure the facial insufficiency. And if you don't, you're outside the 2-year time period. We are giving you this as a matter of lenity and equity. You're out of luck. But the proponents have imported this concept into within the 2-year time limit without really any proof that people are filing abusive or multiple or vexatious filings within the 2-year time period.
Isn't the problem really that because they're being filed pro se, and again, there's a confusion even, I think, I'll put myself there, facial insufficiency, legal insufficiency, those types of things. Some of this could be solved with a very specific form that guides the prisoner through what is necessary. I remember talking to a judge about, here's the menu and then there's the motion. Would the Innocence Project be willing to work with the court and the committee to come up with such a form I guess at first ask, do you think that would benefit the cause of justice and also, and the goals of fairness, efficiency, finality? Would that assist it or would that complicate the matter?
No, I think forms are incredibly important. Any mechanism, any new tools that can be given to inmates, whether it's increased access to legal materials in the prison, increased access to jailhouse law clerks, forms, these sorts of things that can, I think the overarching goal needs to be to help folks get...
So would you be willing to help with that?
Absolutely.
Is that the state of the Florida prisons today? I know I see some that are typed and they come in and they look like a lawyer did them, and then others, of course, are the handwritten. What's is there a difference in terms of the philosophy of certain prisons as to the access to computers, and do any would allow for a way to electronically file these?
Well, Your Honor, I'm not totally sure, what the DOC's policies are. I do, from what I understand, I don't think that there's any computers in prisons. I would suspect when you guys get typed written motions as opposed to the handwritten motions, probably someone outside the prison who is assisting that person to advocate help them. And we struggle with the same thing at the Innocence Project. We have thousands of people write us, and we have to decipher that. I do believe that if the court system is moving more towards being online, being e-filing, these sorts of things, we need to obviously catch the prisoners up as well. But we can't do it if we don't catch the prisoners up, because they are an important part of this. And again, we can't let people fall through the cracks. Let me just get back to one point about SPIRA, and that is that what the proponents have done is said, if you file timely but insufficient now, the judge will be able to deny you, but without prejudice, to file within a 60-day period. And then if you fail to cure the insufficiency within that 60 days or don't file at all, then you can be denied with prejudice, and maybe even before your 2-year time period. And of course, this runs sort of counter to the law as it stands today. This court in Christopher and the second DCA in case Fruby State suggested that if you file a 3850 motion within the 2-year time period, and you haven't had a denial on the merits previously, it would be an abuse of discretion to deny that with prejudice. And of course, they take out the provision in the successive provision, the words relating to denials on the merits, so it makes it easier to do that. But again, we don't see any reason to shorten the 2-year time period. Justice Lewis mentioned before, opportunities to resolve these claims at the circuit court level, so we don't shift litigation to the appellate courts. And essentially, what this is going to do is it's within the judge's discretion to deny that if they don't cure the insufficiency or they don't file within 60 days. But how does one exercise that discretion? And so ultimately, we're going to shift the litigation from the circuit court to dealing with this on the merits within the 2-year time period to the appellate courts arguing about whether the judge should have given that person another chance within the 2-year time period and whether they abuse their discretion or not. I'm not sure that that is a good use, efficient use of resources.
Well, every time a circuit judge makes a ruling, it's going to hit the appellate court. So any determination ruling on the post-conviction motion ultimately is going to find its way to the appellate court, right?
Well, I don't think ultimately, Your Honor. I mean, we see that the number of cases that are filed in the circuit court, just by the statistics that Justice Parente showed, not everybody appeals, but I take your point that people may appeal for whatever reason. And I think that maybe underscores all of this is that we have I've heard 102, I thought it was 107,000 people. Either way, it's a lot of people in prison. The laws are such that we're making more things crimes and making each crime have a longer sentence. As more people are in prison, they're going to keep filing these things, and we can tinker with the rules and tinker with the rules and tinker with the rules to try to decrease workloads and gain efficiency. I'm not convinced that it's going to gain any efficiency because, especially for my clients, there are people who are serial filers.
But let me ask you this. When someone files a 3850, why shouldn't they have to bring up everything they've got to bring up? And if it's facially insufficient, they're given an opportunity to correct it within a period of time. But, why should the courts have to deal with multiple trips to court from the same person over the same conviction when they could put it all in one 3850? I don't understand that.
Well, I think, Your Honor, maybe we're talking about two different things, because I think we're suggesting that it all should go in 13850, but if the person, for whatever reason, is not able to get it right, we've sort of decided in Florida that 2 years is the appropriate amount of time for this person to be able to get it right, to file a facially sufficient motion so we can get to the merits of their motion and move on, okay, and once and for all. And I'm not sure there's a lot to be gained. I mean, obviously,
well, so they go to court and then it just stays open for the whole until the 2 years is up while they are back and forth and.
Well, Your Honor, I mean, first and foremost, there's not really any demonstrable proof that people can get to the circuit court 5 times in 2 years. I mean, I think the court is sufficiently slow that we may be quibbling over a second motion and a third motion. But the reality is that the law as it stands today, we can't deny that person with prejudice within the 2-year time period if they haven't had a denial on the merits previously. And 2 years is a predictable amount of time. Everybody knows you got 2 years. What we're going to move to now is different courts, judge by judge, case by case, circuit by circuit, coming up with different amounts of time within their discretion. So your amount of time depends on when you file within the 2-year time period, how long the court takes, and then if it's insufficient, 60 days after that. That means every prisoner in Florida gets a different amount of time to file. It creates an incentive. My time is up. Can I finish my?
Well, you can keep going since everybody else has. So. I'm not going to cut you off.
Thank you, Your Honor. It just creates an incentive for people to wait till the end of the 2-year time period, and it penalizes the person who files diligently but early but insufficient because they're not skilled in the law. So. Just one more point, Your Honor, just about what we're asking for is I think all the people who have commented, the Public Defenders Association, FACDL, the Innocence Project, we'd be happy to work with the proponents of the rule going forward to try to bring a more defense attorney perspective and also someone to represent inmates who are actually affected by this. We don't think this rule is really ready for prime time, and we'd like to send it back and work with those folks so we can get a more balanced perspective. And we'll make it proceed. Thank you.
May it please the Court, I will be brief. With regard to 3.170L, I will simply note that the Criminal Rules Procedure Committee, in their 3-year cycle report, has also recommended deleting 3.170L.
But how about the issue that Mr. Stanton brings up, which is that you want to have, if there's really, if the, 30 days after somebody says, I want to withdraw my plea, not 5 years later or 10 years later, don't we want to encourage that if there's a reason that they should withdraw their plea, we get it to the trial court then, and then it's preserved for appeal, and then it's clear if they don't do it, they can still file it in 3850. So what's the answer to that?
In the best of all worlds, it would happen that way, but it's proven unworkable.
Why?
3170 is
what is
proven
not workable
unworkable.
about
With
it?
regard to the, especially in public defender cases, what is the role of counsel at that point? What is the role of the court at that point? Appointing conflict-free counsel.
But Mr. Stanton didn't seem to say that there was. I mean, I guess it's trying to understand. Then how would they preserve? If then the issue is, when is the first chance you have after this sentence and
presumably under a 3850.
So it's after the whole appeal has gone,
yes.
And then they don't have a lawyer, but it could have been something that, I don't know, do judges ever, like 30 days after, it's like, do they ever allow the plea to be withdrawn?
I think there are.
I mean, isn't it much more likely, I
circumstances.
guess, the judge is going to do it then, when everybody's memories are fresh? Hey, you want to go to trial and you're going to get whatever you're going to get?
I think it's very infrequent, and I think, especially given the rules of criminal procedure and the makeup of that group, and the fact that you need a two-thirds vote from them.
If it's so infrequent, why do we need to change the rule? If it's infrequent, it wouldn't seem very burdensome.
But the motions get filed. I think Justice Periante was asking whether relief is granted, compared to the number of motions that get filed. If I might address just a couple of other issues that have been raised.
But we know that they don't, the chance of getting them granted post-conviction is almost nil.
Nil, yes, that's correct. With regard to the public records issue that's been raised under 3850, I don't think that that is an obstacle at all. This court in Allen versus Butterworth, when it discussed dual tracking in the context of capital litigation, did request the legislature to review the public records exemption and when the exemption would be lifted. But the two choices there were whether the public records exemption would be lifted at the time of the imposition of the death sentence or at the time this court issues its mandate, meaning at the end of the direct appeal. And in State versus Cocal, it affirmed, at least impliedly, that what it means by final in terms of when the exemption is lifted on public records requests, final means when the mandate is issued from the direct appeal. So there really is no obstacle with regard to public records in 3850 in non-capital cases, because we are determining final to be when the mandate issues from the District Court of Appeal. And I would refer the court to Tribune Company versus Public Records at 493 Southern 2nd 480, which said that pending appeals under the public records exemption does not protect records from disclosure beyond the first appeal as a matter of right. And so I don't think there's a public records problem here at all. With regard to SPERA, yes, we are asking this court to revise the rules so that the defendant, when he files his pro se motion, gets an opportunity to amend it within a reasonable amount of time given by the trial court under an abuse of discretion standard. The defendant gets to choose when he files his motion. We should not allow a defendant to expect that he is going to be able to engage in piecemeal litigation. That's not to say he won't get an opportunity to file a legally sufficient motion with the court, have it decided in one single final appealable order. But piecemeal litigation should not be encouraged. It should be prohibited. There's no other area in the law where we allow that to go on. And in the spirit of SPERA, we think that we should continue by revising the rule in that regard. We thank the court for its time.
We thank all of you for your contribution. I want to thank all the members of the committee for your work, the subcommittee and the committee for your labor on this, and all those who commented. All this is valuable to us. This is a complicated area, and we appreciate the input that we've received. Thank you. we will...
Wow. Is this audible within 25 feet? It's too bad this was the first, this one was
Okay, the court is still in session.
Here's our marshal people.
The court is still in session. If you intend to exit, please exit. Otherwise, be seated and be quiet because we need to get on with the next case. Thank you. The next case on our docket is the state of Florida versus Catalano. If you will just hold for a couple seconds here.
This guy sitting.
Please proceed.
Good. Chief Justice Kennedy, and may it please the Court, I'm Tim Auster House on behalf of the state of Florida. Both this Court and the U.S. Supreme Court have recognized that amplified noise can be a traffic hazard and a dangerous distraction that threatens the safety of motorists, and the government may turn down the noise.
If you could still speak up a little louder, just delay. a little more audible.
Absolutely, absolutely.
She's within 25 feet.
More than 20 years ago, the legislature passed a law restricting amplified noise on the streets.
Can I a question about that? When they did that, was it first at 100 feet, 50, and then it went down to 25?
It was first, Justice Perriente, it was first at 100 feet, and in 2005 it was amended down to 25 feet.
25. Was there any, as far as the statement as to why it went from 100 to 25 feet?
Yeah, there's nothing in the legislative history that I could find that indicated that. I mean, often something happens out there that prompts the legislature to do something like that.
Would you suspend for a minute? We need to have the door closed. We need to have the door closed, and we need to have quiet in the courtroom.
Next.
Thank you.
Thank you. You can proceed now.
Excuse me. Often there is a precipitating factor, but I couldn't find what that was in the legislative history. The legislative history seems to be bare on why it was modified to 25 feet.
The goal is so that, first of all, you should be able to talk to people in the car or the vehicle and not disturb people that are outside the vehicle.
Well,
I mean, so I guess the question is you were sort of telling what the goal is.
Sure. I think the primary goal is safety. It's so that the driver, primarily so that the driver can hear what's going on, so that the driver can hear in that cockpit that the music isn't turned up so loud that he can't hear emergency vehicles or what's going on around them. It's interesting where in this...
How is it any safer for someone making a political speech? Still loud, still driving a vehicle?
Well, the political soundtracks often will have loudspeakers that are directed outward. And also the context in which they operate is generally they're slow moving around courthouses or public parks. They're not ubiquitous. They're not on the streets, on all streets. They're not on Appalachian Parkway or US 1 or US 19.
Well, there's nothing to stop them from being there.
Well, there's something to stop them, but I think that the legislature legislates in the real world, and they see that where these things are operating, as far as the state level concern, the localities do regulate these types of vehicles. But as far as the state level concern, that these vehicles aren't operating at all hours.
So
these vehicles aren't operating on all the streets.
So it's not for noise pollution. I thought it was that I didn't have to hear the boom box that's in the vehicle. But what you're saying is it's to protect the driver of the vehicle from not hearing what else is around, or is it both?
Well, I think it's probably both. I think primarily, though, it's driver safety. If you look at 316.303, drivers can't have a TV on the dashboard. 316.304, they can't be wearing headsets. The idea here is that their senses are there so that they can drive.
If a driver of a vehicle didn't have the speaker inside the vehicle, but somehow put it outside the vehicle, so that would be okay?
Well, the statute says from within the vehicle. Well,
let's say the speaker is directed at, from the inside, but it's outside. So I can hear everything going on, but I want everyone to hear my favorite song that's playing on the radio.
Sure, and I can only go by the text of the statute, which says these sound-making devices from within the vehicle.
If I put my boombox on top of my car, it's okay?
Well, per the statute, again, it says within the vehicle. I think that would be more akin to what you see with the political sound trucks, or even with your business exceptions, which are the only thing I can think of is an ice cream truck. That there, again, the sound is projected out from the vehicle. The driver in that vehicle isn't necessarily being bombarded by these speakers that are directed right at him.
Well, but it's going to make a difference as to whether there's a violation, whether the windows are up or down.
Absolutely.
So it's not going. So that's a factor. Well, let me ask you this. I'm trying to understand this exception, the business and political exception. If I understand the way you're arguing this, it is focused on particular types of vehicles.
That's correct.
It's not whether it's a political speech going on, but whether it's a particular vehicle that is putting forth something.
Absolutely correct.
But the notion is there are some vehicles that put out political messages. It's kind of a part of their business. That's why they are there.
Correct.
Well, why should somebody be able to put out a political message through a vehicle like that when they cannot broadcast a political message just from their car if they want to?
Well, I think
isn't that creating a distinction between some people putting out a political message and other people who might also want to put out a political message, not to mention a religious message or something else?
Well, sure it does, but the state has a substantial interest in safety on the roads, and this court has said that back in the Headley case. The Supreme Court has said that in the Kovacs case, that this safety issue is a big factor. So here,
I'm sorry. I'm still having trouble with what I thought was the purpose and what you're saying is the purpose. If the standard is plainly audible at 25 feet, as was just said, it could depend on whether the window's down or up. That isn't going to be the factor that's going to determine whether I can hear what's going on within my vehicle and outside the vehicle.
Well, the legislature, it is somewhat of a line-drawing exercise, and I think what the legislature recognizes this, and of course 8 or 9 months a year, people do have their windows up, their air conditioners on, and I think that the legislature's thought there is, well, under those circumstances, if you can hear this music three car lanes away, then is that driver going to be able to hear what's going on around him sufficient to operate the motor vehicle safely?
I'm still stuck on if a compelling interest is public safety. How is it any safer for the noise to be coming out from inside the car, actually from on top of the car, than it will be from coming out from inside the car? It's okay for the noise to be emanated from top of the car in those type of vehicles, but it's not okay for it to come out from inside the car.
Well, I think if we're talking about the intrusion factor more broadly, I would agree with you, but not necessarily with respect to the safety factor. That there's a speaker, that there's a loudspeaker projecting noise outside of the car doesn't necessarily compromise what the driver is able to hear if he has, as compared to having his stereo turned up, where all of those loudspeakers within the car are sort of trained for the driver, so that the driver can hear. And
I've recently had to get my license renewed, and you have to have a eyesight test. I don't ever recall having to have a hearing test, and isn't the fact of being able to hear what's going on around which I guess would be the emergency vehicles, wouldn't that be based on your level of hearing? I mean, if someone's elderly or starting to lose their hearing, not so elderly, that's going to impair it. But the state of Florida doesn't require hearing tests before you get a driver's license.
Well, I think that the state of Florida has said that hearing, they don't let you wear headsets.
But I'm saying about hearing, that is,
sure.
If it's, we don't let people drive without, if you have to wear glasses, you got to wear it, or it's a
Sure.
restriction. There's no restriction or test for hearing.
Sure. And maybe what they have in mind is that those drivers who are hearing impaired they know that they are, and their other senses are perhaps heightened, and they take that into account in their daily life so that they account for it.
You really think this was? I mean, was the original motivation? This idea, what you're saying now, is the public safety of the driver, or are you sure? I mean, are you sure it wasn't that people were creating nuisance by just having loud noises coming out of their vehicle?
Well, I think that's part of it. But if you see, again, look at the text of the statute. The statute talks specifically about noise from within the vehicle, and it's in the area of the code where they talk about TVs, they talk about headsets, and they exempt the political speech. They exempt the ice cream trucks that are projecting noise outward. So it seems clear that they're going at what is going on inside the car and the driver's ability to safely operate the motor vehicle. That's what I see in reading the statute as a whole.
Is that if noise can be heard within 25 feet of the car, then the driver can't hear anything. Is that the presumption that's made in the statute?
That's correct. That's correct. That the legislature has drawn a line there.
Why is there an exception here for political purposes?
Well, it's vehicles that are in the business of the political sound trucks, and those vehicles that are in the business of that. I think it's because, again, that their operations are limited. They're not ubiquitous. They're not. The record indicates, for example, that Mr. Catalano was cited at 7:30 on a Tuesday morning.
But
those kind of vehicles don't operate.
There's a distinction here between for business or political purposes. So it's something different than business. So why political?
Well, again, I think it's business. It says such business. I think such business it refers back to business and political uses of these vehicles. I think it's because the other reason is that we place a high value on political speech. In fact, the ACLU's amicus, I think, is with us on this. They don't want us to sever
a core First Amendment right type issue.
That's correct. It's right at the core. The founding core. The founders in framing the First Amendment. Political speech was.
But religious is not included. So isn't the statute then overbroad, because it doesn't include other things as exceptions?
Well, I don't think so. I think, again, that what the legislature drafted here was trying to reach real world, what they see in the real world. And what they see in the real world is there are political sound trucks. I don't think that probably they're often seeing religious sound trucks out there that are being caught up in this. That's just my sense.
Isn't this content-based, though? Because, isn't there an issue that commercial speech actually has intermediate scrutiny? And so don't we, and again, aren't we placing a value on that somebody who can afford to have a special vehicle that, one of these big mobile homes or something, they can get to do it, but if someone's just running for an office and they want to use their own vehicle, that they're not going to be able to do that?
Well, I think that the issue here is safety, and what the legislature has done is drawn a statute and tried to draw lines based upon what would be unsafe, what level of noise inside the car would be unsafe. They've narrowly tailored their statute. That's their obligation. That's the obligation under to have a valid time, place, and manner restriction.
So you would agree that
and they've carved it out.
So it is content. I mean, do you agree it's content-based?
No, I don't. I think it's based upon the safety. Again, that these vehicles operate in limited areas. Your ice cream trucks, residential areas, afternoons during the summertime, or your political vehicles that circle the Capitol or circle the courthouse or what have you during certain times of the year.
But I guess I didn't know, when you use the word narrowly tailored, usually that goes along with a First Amendment right, or you're not. Are you agreeing or disagreeing that there's any First Amendment implication in the statute?
Oh, well, there is a first. This is a time, place, and manner restriction on speech.
Okay,
that's right. So I agree with that, but I think it's a valid time.
And then it's subject to the intermediate scrutiny.
Subject to intermediate scrutiny because it's content neutral and because it's narrowly tailored and it leaves open ample other channels.
But if it's content-based, then you would agree it's a higher standard.
If it's a content-based restriction, which we don't think it is, it's targeted at safety, and that's.
I just, you keep going back to the public safety reason for the exceptions in the statute. I don't see how it is safer to hear a politician make a speech than to hear a preacher give a sermon. Where did you draw the line?
Well, I think that those as-applied cases can be brought. If there's an as-applied problem with this is a facial challenge. This isn't Mr. Catalano or Mr. Schermerhorn's issue. If there's a facial problem in here, I think we could spin hypotheticals all morning and say, that's an interesting case, and perhaps that would present problems. But that would need to be brought, and that could be vindicated perhaps when it's brought.
Well, I don't know if the facial challenge though involves the First Amendment. I think you need to look at all. Don't you have to do that?
Well, sure. If there's substantial overbreadth when compared to its legitimate sweep, the legitimate sweep of this law is I think pretty apparent. I think that we know that there are a lot of loud cars out there that are disturbing, that are distractions, that could present some safety issues. I think we see that out there. So the legitimate sweep here is vast. That there's some problems at the margins of the statute. Does that outweigh the legitimate sweep? I don't think so. I don't think there's an overbreadth problem here because of that.
Do you know where the 25 feet restriction came from? Like it used to be 100 when Davis was decided. Where did that come from? Was there studies or?
No, I couldn't find anything in legislative history on that.
So 25 feet, would you say that's about as far as you are from me?
Perhaps, maybe a little further. I think it's 3 lanes of traffic, so if not there, here. Or back over there.
Well, that takes care of my daughter's car when I'm around.
But of course, that's the legislator's the job of the legislature is to draw those lines, and so they take into effect. We may not be able to know exactly what the 160 legislators took into consideration when they voted on this, but that's their job, and there's been nothing in the record suggesting.
It just seems to me like 25 feet. That's pretty close. Just about anything is going to be audible from 25 feet away. I mean, unless you're wearing earphones or something.
Well, I think that if you're in a car in Florida with your windows rolled up and the air conditioner on and somebody can hear it 3 lanes of traffic away, that's pretty loud in your car.
But that's not a limitation because you don't have to.
3 divided into 25, that's 8 yards. That's about being a former football player. I look in terms of first down.
Sure.
That's really not that far.
Sure, I was a kicker, so I didn't know you quite like you did.
All right, think about 8 yards. That's what you're talking about.
Well, I think standing in one lane, or at least the edge of one lane of traffic.
Are we 8 yards?
A couple.
Not quite.
Excuse me?
Are we 8 yards away? The distance?
Probably. Yeah, it's getting close. And so could we fit a couple of cars between us? Yeah, maybe.
A couple of cars?
A couple of lanes, sure.
Small cars.
A couple of cars.
I think again though that this demonstrates that we're quibbling over the margins of the statute, but the substantial reach.
We're talking about the space and whether or not it really makes sense or not.
Sure. But again, that's a political question for that the legislature looked at, and they decided that it did. There's nothing in the record. If the appellee here would have brought something in the record to say that 25 feet is a problem, then we could talk about it.
We're talking about the plainly audible, and as to whether that's vague or not, or was it that as well as the distance?
Well, no. Actually, in the trial court, and this started out in the county court, and then there was a 3-judge circuit court. All of the stuff that we've been talking about today was not in part of that record. They didn't pass upon it. This all sort of appeared at the district court level.
So what was the challenge?
The challenge was that the plainly audible standard is vague. And we would say that it's not vague. In fact, it's very precise. It says 25 feet, an officer with unaided hearing with a direct line of sight to the car who can identify both the distance and the car from which the noise is coming. It's a very precise standard.
And if they stop, there was something in the concurrence. If they stop the vehicle, then it's a traffic stop, and then they can proceed to do whatever you do in a traffic stop. I mean, in other words, it's a traffic violation just like anything else.
That's right. It's a non-criminal, non-moving violation. It's a fine.
In this particular case, and I guess we can hear from Mr. Catalano himself, but was the noise that was complained of, was it bass-oriented? Was it just a bass too loud, or was it just the melody was too loud?
There's nothing in this record. Again, the challenges here are purely facial, based upon nothing. There's nothing in the record. He said the challenge was that the plainly audible standard is vague and overbroad. So that's.
And let me just make it ask this: can you do a search of a car once you've stopped it because too much noise?
I don't believe so. No, this is if the officer 25 feet away is able to visually identify and hear the car, then he writes the ticket. It
would be the same thing, though, as any traffic stop. If you might be able to search. I mean, it would depend
if you
on
have probable cause or founded suspicion or something. But
sure,
if you saw something.
Sure.
You didn't want to say in your last 20 seconds that we would know it when we heard it.
That's right.
You have used all your time. However, since we helped you use it, I will give you 2 minutes for rebuttal.
If it please the court, Richard Catalano, I'm here on my own behalf and on behalf of Alexander Schermerhorn, who was a co-defendant. We joined the cases for purposes of appeal.
Does the record establish what you were doing?
What I was doing? I'll be happy to tell you what I was doing.
Well, I mean,
driving to work, playing a song.
Just playing a song on your radio?
Playing a song on my radio on 22nd Avenue North in St. Petersburg. Playing a song on my radio. And I pulled over and I said, "Why?"
Could you hear what was going? Could you hear what was going? Did you hear him pull you over?
Did I hear him? Sure. Yes. Excellent point. Yes, I did. Amazingly enough, I did. I did hear him pulling me over.
Was the siren?
He threw on the lights and a siren.
Did what?
He threw on the lights and a siren.
Okay.
I was stopped just for a couple of seconds while somebody crossed the street, and then I proceeded. And then all of a sudden, behind me, the lights go on, the siren goes on. I go, "What is this?" I pull over, and here he is. And I go, "What did I do?" He says, your radio's too loud and you're in violation of 316-3045. What? Well, your radio's too loud. There's a statute on it or whatever. So that was it. He pulled me over and I said, "You've got to be kidding me." And no, I'm not. And license and registration, and there it was from there 4.5 years ago, and here I am today, 4.5 years later.
As I understand your challenge, your complaint is addressed to the plainly audible
Correct.
Phrase.
The plainly audible standard, yes.
And are there other decisions, other courts that have upheld other standards? What you're complaining about now is not liking the application of the statute, and you didn't know what you were doing. But I think really for our legal analysis, we need to really get down to...
Oh, certainly.
Aren't there other decisions, other locations that uphold statutes, ordinances?
Yes, Your Honor.
That use
yes,
phrases that are even more ambiguous than
That's
this.
where we're going to get into the argument on it.
Well,
okay, on the issue of plainly audible. Plainly audible statute, yes, there are decisions from top courts in other states saying plainly audible from 75 feet is fine, plainly audible there's one that says 5 feet. I'll go all that far. And they say everybody knows that plainly audible is 5 feet. All it warrants is a passing reference. Too bad. Not so. There's no reasonableness standard in this statute. That is the problem with plainly audible. It's not based on a reasonableness standard whatsoever. It is vague.
Well, I don't understand. Explain that. I'm not sure I understand. If everybody understands that projecting now that you know the statute exists, that do you, since for 4.5 years, have you now lowered your radio? I mean, do you understand that radios can be loud enough to be heard 3 car lengths away?
Well, have I lowered it in the 4.5 years? No, because I'm in Pinellas County, and now in that second DCA, that statute is illegal.
But I guess what the point is, when you say it's reasonableness is the standard,
right?
That's not that is not a vagueness challenge, is it? Vagueness is, would a reasonable person know what plainly audible from 25 feet is? Right,
but on the issue with regard to plainly audible, it's vague. It is, if you look at the ones that have been passed by the Supreme Court, Kovacs versus Cooper, others cited in the brief, they're talking about the statute was loud and raucous, unreasonably loud and raucous, unreasonably jarring, unreasonably loud,
why
raucous,
is that
jarring,
not?
etc.
It just seems to me that those are far more ambiguous than the word plainly. I mean, that's a word that's used in common parlance, used across the not only the English language but the American vocabulary. And audible. Well, the problem, audible is not some type of word that we have to strain to understand when something is audible, right, capable of being heard.
The problem is that it is an entirely subjective standard. It's based on the hearing of the particular officer and his opinion on what is plainly audible of the officer who happens to be there that day. What is plainly audible to him? It is not a reasonableness standard. It doesn't have to disturb anyone in order to be a violative of the statute. Nothing like that.
Well, disturb, you get into sensibilities and all kinds of things. So to me, that's far more ambiguous than plainly audible. Maybe it's too restrictive, but it certainly is not ambiguous when it comes to do we know when something is plainly audible?
I think it's a matter of opinion, and it's the opinion of the particular person that is there at the time. I would submit that plainly audible to me is not going to be plainly audible to the officer who pulled me over.
Do you accept the fact that the statute is not to protect his sensibilities, but to protect your safety?
No, I don't accept it at all. I would say that everyone is guessing in terms of what this statute is based on, because it doesn't say. It doesn't say anywhere. I think we're assuming the goals of the statute. It says nowhere what the statute is really trying to get, as several of the justices seem to mention. Also,
so is that an important? I mean, is that important for our constitutional analysis? Because it seems to me that if it's rational basis. Then you come up with any conceivable reason and you guess at it. But if it is not, if it's a constitutional standard, then you can't guess at it. So we're just getting, Mr. Austster House just gave us a reason that appears nowhere in the legislative history or the history of the statute?
Nowhere that I have found that talks about it.
But isn't it that it's in the same, isn't it pretty compelling that it's in the same provision where you can't have you agree you can't have headsets when you drive? Is that?
Yeah, it's in that area too.
You can't have a television. Correct. Some places have now outlawed, cell phones, having those and listening to those, so that the driver's not distracted.
Right, but if I may, on the vagueness issue, Judge Moyle in State versus Middlebrooks that was cited said the following: the Florida statute prohibits any noise that is audible from 25 feet. It does not provide an objective reasonable test. It simply makes it unlawful for an officer to hear the sound at a distance of 25 feet or more. And based on that, he found it vague. The second DCA
I guess maybe we're confusing terms.
Okay.
Because a officer, unless, again, the officer, you're saying, well, someone who's a hard of hearing officer isn't going to be able to hear it at 25 feet, but someone with good hearing can discern it. But going back to, it's not what the officer hears, is it, do you now know that there's a statute in place that says it has to be it can't be plainly audible from 25 feet? What that means, that you modulate your radio so that it's not as loud.
I can comprehend what he's getting at. but it means a different thing to me. It means a different thing to you.
See, that's what I guess, and maybe I'm going back to that. You know, I have some other issues with
right,
this.
and I'll get to them.
But I don't see that it is, you know, that it doesn't put you on notice of your potentially violative behavior. I don't get that part.
Okay, and so the court in Montgomery, the 5th DCA decision in Montgomery, goes along with exactly what Your Honor is saying. They're disagreeing with the second, and they're saying, we don't find it vague. 2nd DCA says it's vague and overbroad. They say it's vague. They say, in Montgomery, they say it is not vague, but it is overbroad.
Okay,
and
so
it's
there's now we go
content-based,
to overbreadth. So
right. I will readily admit, in total candor to the court, that of all of the issues, the vagueness is not the strongest one.
All right, let's
but the
Why don't you
overbreadth,
get your strongest?
Pardon me?
Why don't you go right to your strongest?
Content-based.
Well, let's go to overbreadth before. Just because you were saying overbreadth, is that now content? When you get to overbreadth,
overbreadth, yes. Overbreadth. Well, it reaches far more broadly than is necessary. That's the 25 foot. Am I at 25 feet from Justice Labarga now? Can he hear me? Can you all hear me from here? This is a conversational tone. I'm going to get pulled over for this. In Sarasota, they were pulling people over and impounding cars on first offense for that. If you can hear me, am I plainly audible now? I've been given a ticket. I'm driving down on a spring day with my windows. I'm at this level. That's what they're doing. That's why I'm here. The overbreadth is there are no strict guidelines or definite standards as in Daly.
But let me even with that, it just seems to me that if they're correct, that the purpose of the statute is so that people inside of the car can hear if there are emergency vehicles and other things, even though from the 25 feet, it may not be as loud, but from the inside of the car, it would be a lot louder. And so isn't that a legitimate sort of a legitimate thing for the legislature to say?
It's absolutely.
Because you are the one in the car, and you're the one who's going to need to hear these emergency vehicles, that's a reasonable standard.
It's an absolutely legitimate concern, but we're all assuming what their concerns are because they don't say what they are.
Well,
That's the first problem.
I think it's a legitimate reason where the statute is placed. Right. We can draw some inferences from it.
If we assume that's the purpose of it, and I will readily admit the state has a right to regulate sound. I'm not challenging that in the least, but they've got to do it right. It's not constitutional. We're talking about overbreadth.
Well, again, I mean, you're mixing the vernacular of this is not right, this is not fair, this is stupid, what I mean, that's what your point you're making. You stand across the room and speak, and it seems absurd that we'll have to pass a law to say you can't talk in your car because it's going to keep you from hearing something. We need to get to the constitutional basis for it.
Yes,
whether we like it or not and agree with you, I mean, we can't rule on that.
Right. No, I understand, Your Honor. If I may get to the content-based issue, okay? On the content-based issue, the business and political exception, that to me is fatal to fatal based on City of Cincinnati of the U.S. Supreme Court. The moment that you carve out, you make these carve-outs, and any kind of law along these lines, the case law cited in the brief states, anytime you make these kind of carve-outs, it has to apply to across the board to all kinds of noise. You cannot favor one above the other. You cannot regulate one based on the content. You cannot, the moment that you have a content-based restriction, which is what I believe these are, the business exception and the political exception, why is it that if I'm running for office, I can be in a sound truck and get on there and as loudly as I want say, vote for honest Rich Catalano for mayor. And I can do that. And they can't touch me for that under this statute. But if I play Led Zeppelin Houses of the Holy, or if I do anything like that, or if I make a religious speech, I get a ticket. And not only that, at 25 feet, if I'm plainly audible, at 25 feet, I get a ticket. But if I make a political speech there, then that's fine. I think I understand why they put it in, because political speech enjoys such a high level in constitutional law that they knew that if they didn't, they were going to have a constitutional problem. But it's kind of, they shot themselves in the foot is what it appears. By putting that in, it makes it a content-based restriction, and unless the state has a compelling interest, it fails. It's presumptively unconstitutional under City of Cincinnati and other U.S. Supreme Court law. So on that basis, it's a problem. Then is severance, the issue of severance. I want to get to that. In terms of the cramp test, I believe the third level of the cramp test that looks at it, I don't believe, first off, I don't believe it meets any of the requirements of cramp. On the third level of the cramp test, if we take it out, I don't think that the statute is going to stand, that it's going to stand. I don't see how it does. Basically, I have, here it is. The legislature specifically carved out those exemptions to protect political speech, and they would clearly not have passed the statute without them. And that was, under cramp test, you know, the third rung of that is the good and the bad features are not so inseparable in substance that it can be said the legislature would have passed the one without the other. I don't see how the legislature could have passed it. They didn't pass it without it because they had the House bill and the Senate bill. The House bill had both of these in it, the business and political exception. The Senate bill did not. They passed that one. That was a conscious decision.
Now, that was in the original, the first bill that was at 100 feet.
The 1990 original statute.
Did that have a political commercial exemption?
Yes.
Okay, because I thought maybe that was put in.
Yes, I believe that to be so. In 2005 is when they did the 100 feet down to 25 feet.
Would 100 feet be, would we be in a different situation as far as the reasonableness or the lack of overbreadth of that? That, in other words, 25 feet may be debatable, but 100 feet is...
Yeah,
it's got to be.
Well,
I mean,
it's 4 times better. Let's put it that way. At 100 feet, disturbing, plainly audible at 100 feet, where it was, is one thing. Plainly audible at 25 feet is much more restrictive, and that's the overbreadth. It's throwing a dragnet. It's catching far too much. And in fact, Judge Black of the Second DCA felt it was literally, he said this, killing a mosquito with a machine gun. He felt it was just going far too far to break down to 25.
What are you saying about impounding vehicles?
Pardon me?
What are you saying about impounding vehicles?
That was in Sarasota. They, on the back of 316-3045, it was a separate local ordinance they passed, but it was on the back of that. And if you violated 316-3045, they were, on a first offense, they had the right to give you a ticket and impound your vehicle on the spot. Impound it, order you out of your car, impound the vehicle. You don't get it back until you pay the ticket, and you pay the tow charge, and you pay the storage charge.
This is not the state statute. We don't have that.
No. As I said, it was, but it was on the back on 316-3045. It was on the back of that statute. Okay, but anyway, also on the severability issue, I don't believe if you look at cramp, the 4 levels of cramp, I don't see that it passes. The unconstitutional provisions can be separated from the remaining valid provisions. While I guess they could technically be separated, it's our position that the remainder of the statute that is there is void. It's unconstitutionally vague and certainly unconstitutionally overbroad, what would remain. The legislative purpose expressed in the valid provisions can be accomplished independently of those which are void. Again, we feel that they fail. Also, under the last of it, of the cramp test, an act complete in itself remains after the invalid provisions are stricken. And as Justice Pariente said in the Longwood case, it cannot be said the statute would be an act complete in itself once the invalid portions are severed.
Why? But in this case, the severance would be, the exceptions would be removed.
Correct.
So you'd still have the basic ordinance or the state statute with the limitation, just without the exceptions.
That's correct.
And so then your position is that the exceptions are necessary for the constitutional validity for?
I say that they're an unconstitutional content-based restriction. But if you take them out, it fails as well. That's the craziness of this. Because now those are there for political speech, which is on the highest rung of everything. If you take that out, political speech is plainly audible within 20. Now it's subject to plain audibility at 25 feet. Thank you. That is exactly correct. Plainly audible at 25 feet on political speech if you sever Section 3. You can't. If you sever 3, political speech is subject to 25 feet. That's how does that pass constitutionality?
You can do it as a intermediate in scrutiny, reasonable time, place. I mean, again, if the goal was to eliminate noise pollution,
presumably, yeah.
Well, it seemed to me I thought that was what was driving it. Then, they can limit it, and you can't drive your car with loud music after 6 o'clock at night. I mean, you can put reasonable time, place restrictions if it's not content-based.
Correct.
So you can apply it to political speech as long as you're not discriminating and it's a reasonable restriction.
But the law is still there. It's still going to be subject, but it doesn't have any time. It doesn't contain.
No, I understand that, but you were sort of saying they couldn't do it because it's political speech, but you can do it.
Oh, yeah, if you want to rewrite the statute, you certainly could, but this statute fails. First off, on the vagueness, in my opinion, based on what I stated, on the overbreadth, then it's content-based, and the question whether it's content-based or not, I don't know how you say it's not when you've got the exception for business and political.
It does
and then
seem
if you sever it, you've got a major problem.
I think one of the problems, I'm going to go back to plainly audible, and it was what Justice Labarge is saying, if you have your window up and the air conditioning's on, and the music is pretty loud, it's not going to be plainly audible by 25 feet, but you may not be able to hear anything going on in the outside because it's that loud. So it doesn't really protect. The problem is the outside standard doesn't protect the interest of the inside.
I understand
Maybe that's a friendly question, but that's where I see the problem being. If it's to protect me, then we ought to limit it. It ought to be what is audible within the vehicle, of decibel levels.
Right, and as you said before, I heard them when they pulled me over. It's not in the record, but my windows were up. They were up at the time, and I still got pulled over. Yes, I have a subwoofer in the trunk, and maybe that's what he heard. Aha, there it is.
The truth shall prevail.
I'm nothing if not forthcoming with the
It's lucky that's all you have in your trunk.
All right, I see my time is up. And
that's just my subwoofer.
It's just my sub. I'm sorry. But in summation, I see 30 seconds remaining.
No, actually, you're 30 seconds over.
Oh, I'm over. I'm sorry.
Yeah, we had someone there who kept the longer he was in overtime, the more time he thought he had.
I'll take that. I'll take that. All right, thank you.
Just very briefly, it seems like we've reached some sort of agreement here on subsection 1 of the statute. As far as subsection 3, we think that if you have a problem with that, and you find
Justice Perriente's last question, which is, if the statute is designed for the safety of the people in the vehicle, what does the 25 feet have to do with that?
Well, you have to start somewhere, Your Honor. I think that with 25 feet, if you can hear that, then you know that they're not going to be able to hear in the car. Should it be 5 feet? Well, in Alabama, it is 5 feet. Should it be 10 feet? In Detroit, it is 10 feet. So, yes, the
other
legislature...
places, it's 100 feet.
Excuse me?
In other places, it's 100 feet.
And in other places, it's 100 feet. They're probably thinking more of the intrusion factor as opposed to the safety
again, if
factor.
I have a vehicle and I have a lot of kids, say I'm driving I have a big vehicle and I have 8 grandkids, and they are all talking really loudly, but the window's up, and of course Justice Paulson's thinking this because he's got something like that situation. Shush, shush,
you can
shush.
hear them too.
You are hearing the noise that's going to be the problem is the noise within your vehicle. So you put your window up because you don't want to have other people have to hear your kids, all arguing within the, but it's the purpose of the statute isn't being met then. Is that not,
I think it would be hard to draw a statute along that line. There are general noise statutes that apply to vehicles and ordinances out there. There are muffler statutes. So there are other places in the code that address noise, but But yeah, I would have it would be hard for them, I would think, to draw a statute.
Would somebody know, reading
the
statute, that that's what what it was intended to do? In other words, he gets pulled over, Mr. Catalano gets pulled over, and he doesn't know what's going on. Shouldn't we have, if we're going to have the statute say plainly audible so that a driver in the vehicle can hear emergency vehicles and police vehicles? Because that's really the two. I don't know what else, and horns honking.
Sure, I think we can always draft a better statute, perhaps. But I think that they've been pretty clear here. They talk about from within the vehicle, sound, stereo noise from within the vehicle that travels 25 feet outside of the vehicle. I think it's clear, and also from the placement of the statute.
But it's not just sound. It is limited types of sound. It's not any sound. It is radio, tape player, other mechanical sound-making device or instrument. It's not voices. It's not.
That's
not
right.
just
It's amplified. It's amplified
right.
sound. Yeah, that's correct. So that was the purpose of this statute. We would say that if your problem is content with subsection 3, we would ask you to sever it. The Florida law prefers severance, Ray v. Mortham. The magazine publisher's case that we've cited in our papers, there you had a similar situation where a tax wasn't being applied to newspapers but to magazines, and you struck the exception for the newspapers. So we'd ask you to sever. Thank you.
All right. We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All right.
We now come to the third case on our docket, the estate of McCall versus the United States of America.
Mr. Chief Justice, and may it please the Court, my name is Robert Peck. I'm here on behalf of the estate of McCall. This tragic case presents two basic issues. The first is whether the per-incident cap violates equal protection because it treats claimants differently on whether there are multiple claimants arising out of a single nucleus of operative fact.
There's a problem that I see, and it's always unique when we get questions certified by the 11th Circuit. They answered the equal protection challenge to Florida's law under the federal Constitution. We have consistently applied the state Constitution equal protection in a similar way. So if I agree, let's just assume I agree with you that I looked at the Wisconsin case that was written several years ago, and I think that case is very well reasoned, and just say I agree with you, but our hands are now tied in this case because a decision on the merits was made by the 11th Circuit on the equal protection. So I don't, all your arguments might be very good, but I don't see how they're directed to us at this point in this case.
Your Honor, this Court has consistently said that while persuasive, the most a federal decision under the Equal Protection Clause is advisory to this Court.
Of course. If we were now, next time, we had a case from Florida, not involving the federal government, involving a practitioner that committed medical malpractice, and it was a severely brain-damaged individual, and there was an argument about the cap in that situation. We'd look at it, and we'd look at the 11th Circuit opinion and say that's maybe persuasive. That opinion, that's not binding, but that's not what we're here on. We're here on a certified question. So how do we have authority to answer the question as to the equal protection under our state constitution differently in a certified question posture?
Well, because
you understand what I'm asking?
I understand exactly what you're saying, and of course, the cognate provision in Florida's Constitution need not be interpreted exactly the same, and there are decisions of this Court that has done so. In fact, the 11th Circuit assumed that the Florida Constitution would be sufficiently different that it certified the equal protection question to this Court. So therefore, it did not believe it was deciding that question in a way that's binding upon this Court.
Do you know any decision of this Court that's interpreted the equal protection clause of our Constitution differently than the federal Constitution? I don't know one. One obvious
example would be Bush versus Gore, which this Court decided first, finding it no equal protection, finding an equal protection violation.
We didn't even address an equal protection argument. We didn't address an equal protection argument in that case. There was no constitutional argument was presented to this Court.
Mm-hmm. And while there was also the privacy portion of the decision dealing with parental consent,
honestly, you're Bush v. Gore, as Justice Lewis said. We didn't interpret equal protection. If we had, we might not have been where we were, but we weren't presented with a constitutional argument. So there's my problem. My suggestion is let's look at the right of access to the court argument.
I'm happy to do so, but let me point out that I think, as we pointed out in our brief, that one flaw that makes a difference here in the 11th Circuit's equal protection analysis is its focus on incident as being the pivot point on which the question turned. In its famous decision on one person, one vote, the United States Supreme Court reminded us that it's people, not trees, not acreage, that counts. And here I would submit under the Florida Constitution, it's people, not medical incidents, on which the equal protection turns.
Is the analysis on all of these issues, that is the equal protection, the right of access to the courts, the other constitutional challenges that you make, right to jury trial, is it this exact same for wrongful death, which is what this case is, than a catastrophically injured individual? And because I have problems making the same analysis, especially because wrongful death is a creature of statute that didn't exist at common law, and this is a wrongful death claim. And it is ironic that we're even going to be looking at right to jury trial when the case involves a non-jury bench trial in a Federal Tort Claim Act situation. So I know that's part of the frustration. I realize we're asked to decide these questions, but I'm sort of wondering, why not, why can't we just tell the 11th Circuit, under the posture of this case, we don't want to answer these questions?
Well, because the 11th Circuit, in certifying that question, specifically said that their construction of the Federal Tort Claims Act, which I would say is binding on this Court, requires a decision on whether or not the cap applicable to any other medical malpractice claimant violates access to the court's order.
So do you agree, though, we can limit it to wrongful death? The caps regarding wrongful death cases, which might be different than a cap for catastrophic damages. I mean, somebody who has, and I read the district court opinion, very well done district court judge, a 10-year-old boy who is severely injured and is limited to $1 million for the rest of his life is, to me, markedly different qualitatively than a tragic death for the survivors who might have the pain and suffering. So I think we distinguish wrongful death from other kinds of cases, and yes. I wondered if you were comfortable in our limiting this to wrongful death cases.
Well, as I suggested in my brief, the fact is this cap applies in causes of action based on medical malpractice. It might be a different analysis if the cap was contained and applied to all wrongful death cases. And because the task of the jury in determining the facts, including the amount of compensation, is the same regardless of the extent of the injury. But
we've approved, in a case that I dissented on, the exact situation in a wrongful death case where no adults could, children could recover if their elderly parent dies as a result of medical malpractice, the Ms. Rahi case.
Yes, but the difference there is that there was no cause of action at all for those adult children. On the other hand, there is a cause of action for all medical malpractice claimants here. It's just that some will get more than others. Well, now, that's the fundamental flaw.
I think you misunderstand Florida law. Just because it's a medical malpractice action would not remove it from a wrongful death situation.
I understand that, but what I'm saying is if this were a cap on wrongful death, it would take advantage of the fact that the legislature had created the cause of action of wrongful death. But because this is a medical malpractice cap
that would be applied in that context, then it should make no difference, is what your argument is.
It should not make any difference because, as this Court's precedents and the United States Supreme Court precedents under the Seventh Amendment indicate, that causes of action that are similar in nature, that have the same legal content, in other words, there is a cause of action for damages that is committed to the jury's province, ought to be treated the same.
It seems to me, though, that case was dealing with whether there was an equal protection violation, and it held it did not. We've got the case of Escharte and Justice Barquette's dissent. Aren't we bound, whether you might like it or I might like it or not, by the precedent of this Court in a series of decisions?
Well, I would say you are bound, but I would say that the relevant precedent that you're bound by is Smith versus Department of Insurance and not Escharte.
Well, how could, if we're dealing with medical malpractice, how could Smith be more applicable than Escharte?
Well, because Escharte was a decision solely on the access to courts provision. While it mentioned other constitutional provisions, it did not have any analysis to that, and so therefore it is mere dicta that does not have any persuasive or precedential value. But at the same time, it noted that the decision turned on the fact that there was commensurate benefit to the plaintiff, that even in the instance where only the defendant elected to go to arbitration, there were benefits that flowed to the plaintiff in the fact that they no longer had to prove liability, that they had an opportunity to collect attorney's fees, they didn't have the cost of having to produce experts. Like Smith, there are no benefits that flow to the plaintiff in a medical malpractice case.
Can you just give me, and I know we made this connection, but I'm still having trouble with it, how, I understand under Kluger you had the PIP statute, so people were actually precluded from going to court. Here in Asharte, there was a situation if they accepted the arbitration, you'd end up not in court. How is if you take sovereign immunity, there are caps on damages. How is that an access to courts issue? I know someone had made those leaps, but as I was looking at a right to a violation of the right to jury trial, where is it that if your client, if this was a jury trial, received about the client's estate, and again, this is a horrible facts as far as this terrible malpractice that occurred here, and but the judge awarded, say it was a jury, awarded almost $1 million in economic damages, and then had awarded $755, what would have been $2 million.
Right.
And so it's reduced, so it's $1 million less. How does that, if that was a jury trial, same thing, how did that limit access to courts?
To the extent that there is $1 million in compensatory injury that is not being compensated, there is a limit on the access to courts to receive that compensation. As
so
a factual finding,
it's only the difference between what you could have gotten under the common law? Because that's where we go back to wrongful death. Is that what it is?
What the fact finder found was the proven facts that require compensation to that extent is what is missing. And so that difference between the $1 million that the cap permits and the $1 million that is not being compensated is the difference. And it's basically saying you have a partial access to the courts.
Well, is that, though, should the analysis, though, for those situations versus workers' comp, PIP, where you're actually, there's pre-suit mediation, which apparently didn't help much in the crisis, but should the analysis be different?
The analysis has to be.
Because, well, maybe it should be you're not being denied the access, you're just not getting as much money as you'd like to get. Why should that be the same Kluger versus White, whether you are denied access completely versus that you're limited in your damages that you're
again, I think the Smith case speaks to this and says that this is not access to courts as it has heretofore been understood. The fact of the matter is that workers' compensation, no-fault arrangements, PIP statutes, those are either statutorily created causes of action that define the extent of injury that you can claim, or in the case of workers' compensation, there are offsetting benefits. And those offsetting benefits make all the difference, which is why removal from the jury's province takes place in workers' compensation.
So we now go ahead.
But as I understood Kluger, when you have on these access to courts issues, you can either have, and this is in derivation of the common law, that you can either have something that the legislature has put in place that sort of augments that right.
The alternative benefit, sure.
The alternative benefit, or that there is some great public necessity for it. And so in Smith, the second part was not argued. It was simply the first part, which was the alternative benefit, and they said there's no alternative benefit.
Right.
But in this case, don't we have the second possibility, which is the public, the great public interest here, and the insurance crisis that the legislature has
but those same claims of overpowering public necessity, even though not decided by this court, were present in the legislative findings in the statute challenged in Smith. And what you have here...
But was that actually the basis of Smith, though?
It wasn't the basis of Smith, but The legislature said it was motivated by a crisis in the insurance industry. It said doctors were leaving the states, businesses were having an impossible time in getting liability insurance. They were all the same kind of detailed, and the Smith Court referred to this as detailed legislative findings, and they found that that did not change the equation. Here, we know that the financial responsibility law of the state requires doctors only to have $250,000 in medical malpractice insurance. Testimony before the legislature indicated that 85% of them only have $500,000.
So would you have been happier? I've read that. Would you have been happier if they made the cap at $250,000?
No, and
I mean, happy. Would it be constitutionally?
The would still exist. It's just as if, if the legislature had the plenary authority that the United States claims it has to address a crisis, it could change all damages to $1. But that clearly would not give you access to the courts. It would not provide redress of grievances. And no matter what the overpowering public necessity might be, which I contend is not here, because it does not, what we've shown is that part of the findings that motivated this legislature were in the legislation before the hearings. The task force indicated that there was great ambiguity about the nature of what they were finding, and that there was not necessarily a crisis, but there could be one. And if you look at all that, and you look at what narrow amount of cases, 2% of all medical malpractice claimants bring cases. 95% of them end up settling, and the median settlement, according to the United States Justice Department for Florida, is $213,000.
But isn't the fact that you have a predictability on the non-economic damages helps to then in the negotiation process, because it's not that there's just this unknown amount out there? I mean, again, I understand everything you said, but it seems to me that reasonable or overpowering public necessity, you're asking us to make our own decision as to whether in 2003 there was an overpowering public necessity. And I don't read our precedent as allowing us to make our own separate evaluation of the wisdom of what the legislature did. And you're not, I mean, I don't think you can have a crisis in 2003 and it just keeps on going for 40 years. I mean, but you haven't really raised that issue.
But frankly, if you look at the second part of that it not only has to be overpowering public necessity, but that there has to be a lack of arbitrariness that actually leads to resolving that problem or addressing the problem. What I'm suggesting to you is, by virtue of the nature of the judgments that are rendered in courts of Florida, we are not seeing the kind of unpredictability. We have the Justice Department report, which we cite, indicates that less than 5.5% of all cases in Florida, in medical malpractice cases, result in judgments, economic and non-economic, above $1 million. So the number of cases that involve a judgment of non-economic damages above the cap is even a smaller percentage of that. And of course, the legislature made the decision that in death cases like this one, a larger cap ought to apply. So those cases are extraordinarily rare. There is no way that such a tiny incident of medical malpractice cases can have that effect or be unpredictable. Moreover, we know from the case law of this state that non-economic damages are based on the facts that are produced in the record. And we find that to be a factual finding by the jury. It is not something that's speculative under our law. And in fact, it's no more unpredictable than economic damages, because this person makes a lot of money, and so their lost wages are high, and this person doesn't make a lot of money, so their lost wages are low. The fact that someone has a career as a pianist and they've injured their hand and no longer can pursue it makes a difference to someone who's injured their hand and doesn't have to use that hand for any kind of economic labor. So the unpredictability and the fact that medical inflation continues to outstrip consumer inflation shows that this is not addressed to a problem of predictability. Moreover, as I said, the decision of a jury determining non-economic damages are a fact. Florida's Constitution requires that the jury's verdict be treated inviolate. The only way that we change that verdict is a suggestion of remitter with the right to pursue a new jury trial if you're unsatisfied with the remitter. There's no authority to change what the fact is that's been found by the jury. And this amounts to a fundamental structural assignment of authority to the jury that neither a court nor the legislature can infringe. And this statute clearly infringes that. That is the basis on which just 2 years ago the Georgia Supreme Court, relying on their own inviolate right to trial by jury, invalidated their cap, and other states have done the same.
Counsel, you have used almost all your time. I will nonetheless give you an additional 2 minutes for rebuttal.
Mr. Chief Justice, and may it please the Court, Daniel Lenners for the United States. 19 years ago, in University of Miami versus Echarte, this Court addressed the constitutionality under the Florida Constitution of similar caps on non-economic damages as are at issue here.
But I thought, and I have read all the cases, just they're all blending together right now, that did have to do with the what would happen if you went to arbitration.
There were two caps at issue in Echarte, Your Honor, one of which was a $250,000 cap on non-economic damages if both parties agreed to arbitration. The second cap was if the defendant offered arbitration and the plaintiff rejected it and nonetheless went to court, there was a $350,000 cap on non-economic damages. So that cap on non-economic damages applied notwithstanding the fact that arbitration was not implicated in that case. And this Court found that those caps on non-economic damages did not violate the Florida Constitution's access to courts provision, did not violate its equal protection guarantee, and did not violate its jury trial right.
Let's go to the access of courts, because at least that's not been addressed by the 11th Circuit. What was the test in Echarte? Do you recognize that the test is there has to be an overpowering public necessity?
Well, in Echarte, Your Honor, the Court addressed both prongs of the Kluger test, both the commensurate benefit prong, which we don't assert here, and the second prong, which is the overwhelming public necessity.
And how do you look at, there have been, for as long as since I've been in practice, different types of medical malpractice crises that are usually related to, business cycles. Is it anything that the legislature says there's a crisis, and there's testimony there's a crisis, that the court has to accept the fact there's a crisis? In other words, what is the evaluation of those statements?
Your Honor, this Court's review of legislative fact-finding is extremely deferential. This Court has consistently deferred to legislative fact-finding unless those facts are proven to be clearly erroneous. If the Court determines that the existence of a crisis is in fact a fact subject to determination, I think the Court should nonetheless defer to the legislature's judgment, as it has repeatedly done, not only in the Echarte case, but in other similar cases, such as Ms. Rahi.
So if it's an overpowering public necessity, there's a crisis. Does that crisis that starts in this case, 2003, are they entitled to say there's a crisis in perpetuity? Say it's a mortgage foreclosure crisis and there's statutes passed and they restrict rights. Does that get to stay in the law forever? I mean, without it ever being questioned because in 2003 there was a crisis?
Well, Your Honor, I have several answers to that question. One is that while plaintiffs obliquely mention the suggestion that a crisis can abate, that's not an issue that has been directly presented to this Court here. Second, I would say that there's no evidence that the fundamental circumstances in Florida have changed such that the crisis no longer exists. What the evidence shows, as the Florida Office of Insurance Regulation has found, is that the changes to the law in 2003 have stabilized the medical negligence insurance industry in Florida. So
can you look, and I did see that study, but there are a lot of changes. Like there's pre-suit mediation. There's you got to find an expert. There was a whole host of things. And so on this one, concern I have always had with these caps to try to understand how it helps doctors or the insurance companies it is, again, no question, it is unequally impacting the most seriously injured and catastrophic injured people and children. 10-year-old loses his sight, and that pain and suffering is capped for the rest of his life. It's $1 million, whereas somebody that had a bad result from surgery, that's they get the full measure of compensation. It's really their argument. If it's true, and in those cases with the catastrophically injured, the bulk of the damages are the economic damages, which have, as we know with the neurological birth injuries, can have. That's where the big damages are. So where was it ever established that the amount of the non-economic damages, just limiting, it wasn't a schedule so that somebody, it's $100,000 if you only have this kind of injury, but it's only for the most catastrophically injured, that curbing those to $1 million was going to have any effect on anything. And, was that, am I missing something? And do you understand what I'm asking? Is that
I
just don't
see
the connection. I appreciate the crisis. I know that doctors, it's for them to always be under the threat of feeling like they're going to be sued, and it's anything they can do where it feels like it's going to be a little bit better, it feels better. But how is it really helping doctors for in those kinds of, if it's such a small percentage of cases?
Well, Your Honor, I think the answer is that the Florida legislature built a mechanism into law to ensure that medical negligence insurance became more affordable as a result of these caps. And that's the statutory provision that we pointed out that required the Florida Office of Insurance Regulation to determine the savings that would be provided by the 2003 law, including the caps, and to mandate that medical negligence insurers in Florida incorporate that savings into their next year's rate filing. And so that's what occurred in 2003. The Florida Office of Insurance Regulation determined that this statute would provide a 7.8% decrease in medical negligence insurance premiums, and it mandated that insurers in Florida incorporate that decrease into their next year's rate filings. And so that precise mechanism is what the Florida legislature used to ensure that the medical negligence insurance providers in Florida would pass the savings provided by these caps on to doctors, thus ensuring that doctors continue to practice in high-risk specialties, continue to treat high-risk patients, did not leave perhaps undesirable areas, and thus ensuring Floridians access to the necessary health care. And the Florida Office of Insurance Regulation, as I pointed out, found in its 2010 annual report that these caps and that the legislative reforms enacted in 2003 were working, that they had stabilized the insurance market in Florida, that insurers that had been threatening to leave the state did not leave the state, that something like 18 new insurers entered the state after the reforms. One of the amicus briefs goes into more depth in this issue. But these insurance reforms have worked and continue to work. Plaintiff's suggestion that the crisis has abated because the reforms worked, if accepted, if taken to its conclusion, would require this court to overturn this law, sending Florida into another crisis, requiring the legislature to react, and it would perpetuate this boom and bust cycle that has afflicted medical negligence insurance in Florida. These caps have worked for the past 9 years, and there's no suggestion that they are not continued to be needed going into the future.
Is there a difference in terms of the analysis? And I think that's, I appreciate it's a very substantively helpful answer that you provided. Does it matter that we're dealing with a wrongful death versus, I was asking that to plaintiff's counsel, versus a catastrophically injured individual in terms of any of the arguments?
I think it certainly matters for plaintiff's jury trial argument, Your Honor. As we pointed out in our brief, in this court's precedent in the 1978 Chevrolet van case, when evaluating whether the jury trial right has been violated, the court looks to whether the cause of action at issue predated Florida's first constitution in 1845, I believe it was. And as this court has pointed out, there was no cause of action for wrongful death at common law. So there was no cause of action as exists here at common law predating the Florida Constitution's first enactment, and thus the caps on these damages cannot possibly violate the Florida Constitution's jury trial provision.
What about access to courts?
I'm not sure that the fact that this is a wrongful death action versus medical negligence action implicates the access to courts inquiry, other than the fact that I'm not sure that it implicates, but I haven't focused on that issue.
I guess what I see is, because again, I look at I don't know if I'm saying it right, Ms. Rahi, it seems that because the legislature creates the categories in wrongful death, adult children or minor children, they've changed that over the years. It just seems, in terms of the constitutional rights, it just seems that the analysis has to be different in some way. It's a friendly question than if it were just a case of personal injury that has recognized elements that have been there since common law.
I understand. Your Honor, we haven't made this argument in our brief, but in the Kluger case, the court looked at whether the cause of action existed in 1968 at the time of the reenactment of the Florida Constitution at that time. However, the access to courts provision predates the Florida's 1968 Constitution. It existed in the Constitution that predated the 1968 Constitution. I'm not sure if there was a third Florida Constitution before that. So it could be that if the court wanted to distinguish wrongful death from medical negligence directly affecting the plaintiff, that it could say that that part of Kluger was wrong, that the court should look at whether the cause of action predated the enactment of the access to courts provision historically, not simply the 1968 enactment of the access to courts provision. And in that way, the court could move the line back. And like the jury trial provision, there was no common law right to sue for wrongful death. And in that way, the court could distinguish the wrongful death case that's at issue here from perhaps the direct medical negligence case that could come down the line and find no access to courts violation because there was no common law right to this cause of action. I would similarly say that, Your Honor, as plaintiff's counsel, if there is an access to courts violation here because access to courts has not been altogether denied, simply a limit has been placed on damages. Again, we have worked within this court's past precedent in Acharte and other cases, the Smith case, that have found that caps on non-economic damages do implicate the access to courts provision. We have not argued that those cases should be overturned, but it would not be without a principle basis in law to say that there is a difference between outright elimination of a cause of action, as existed in Kluger, as exists in many of the no-fault insurance cases, and the limitation on damages. Ms. McCall's survivors were able to go into court. They were able to sue the United States. They recovered substantial economic and non-economic damages. And within that framework, it wouldn't be it would not be unusual for this court to find no access to courts violation with the recognition.
Actually, if they were suing in Florida and they were suing the state of Florida, they would be severely limited just by sovereign immunity on what they could get. The Federal Tort Claim Act actually, even though it's non-jury, gives better compensation. It looks like. What is your argument on his main support of Smith? How is that distinguishable?
Well, Your Honor, the access to courts provision, as Justice Quince pointed out, Smith did not address the second prong of the Kluger test at all. It simply found that there was no commensurate benefit. We have not argued here that this statute provides a commensurate benefit. We have simply argued that it satisfies the second prong, as this court found similar caps to satisfy in a charte. And we think a charte is directly on point, and thus Smith really has no bearing on the access to courts issue.
This case was brought under 766.118 sub 2.
That's correct, Your Honor.
And in an equal protection analysis, do we look at the other subsections of this statute to determine overall if this cap on damages violates equal protection? Because, I find it very interesting that, there's a section on non-practitioners and what the cap on their damages, the economic damages are for those patients. And then you have the section where there's a different cap on economic damages if you're a person on Medicaid. And so I'm wondering if you look at all of these other subsections in making our determination about the equal protection, whether there's a violation of equal protection.
Well, I think the fact that there are other limitations on damages that apply in different circumstances underscores the fact that the legislature was acting carefully here and drew these lines for a reason. For example, to encourage physicians to continue to practice high-risk specialties, such as emergency room care, the legislature enacted a lower limit on non-economic damages in emergency situations.
However, why is there a lower cap on economic damages for Medicaid patients?
I'm not aware of that provision, and I don't think it's at issue here. The second part of my answer was Ms. McCall, as I understand it, or Ms. McCall's estate, brings an as-applied challenge. The statute as applied to her is unconstitutional. And the only provision of the statute that was applied to Ms. McCall was Section 2. Ms. McCall, I mean, certainly under federal understanding of standing, I don't believe would have standing to argue that the statute's unconstitutional because of these other provisions.
That goes back to my original question. Do we even look at those sections in making these other sections in determining the equal protection issue?
I don't think that the court could rule that it violates the equal protection clause because it finds a flaw with one of the other sections. However, I was pointing out that the other sections can inform the court's analysis as to whether the legislature was acting rationally. And in fact, here, it didn't just draw some arbitrary line, as plaintiffs have suggested, but after evaluating the 345-page task force report, after hearing expert witness testimony, after looking at thousands of affidavits from Floridians, the legislature developed a relatively complex structure of caps on non-economic damages.
I mean, actually, as was pointed out, this is more, quote, generous. I mean, than the task force recommended, right? They recommended a lower cap.
That's right, Your Honor. The task force recommended a $250,000 cap. The legislature found that cap was not appropriate and instead created a scheme with more moving parts.
Does the amount of money matter? There's a suggestion, well, if you allow the $1 million cap, they could one day make it $10. How does that affect the analysis?
Well, I think the court has to look at the caps that are before it and the savings they were found to provide. Clearly, if the legislature capped non-economic damages at $1, there would be a different question as to whether that particular cap was rationally related to a legitimate governmental interest.
Well, and obviously, the less compensation you provide, presumably the lower the insurance premium, since the risk is reduced substantially. So anytime you lower the benefits that are going to be paid out, you presumably are going to get a lowering of the premium.
I understand that, Your Honor. I'm simply saying that while it may present a difficult question for the legislature to have put a $1 cap on non-economic damages, they didn't. They gave a $500,000 cap on non-economic damages against practitioners. That's increased to $1 million.
Let me ask you on a right to trial by jury. Judge Rogers, in footnote 37 of her opinion, as I understand it, did not reach that issue. Is that your understanding, that the district court did not reach the issue of a trial by jury because it's under the Federal Tort Claims Act?
My understanding is that I read Judge Rogers' opinion as saying that the jury trial guarantee is not implicated because the Federal Tort Claims Act gives no right to a jury trial. The United States did not make that argument before the 11th Circuit and has not made it here.
So should we even reach the third issue as to whether or not it violates the right to trial by jury?
If this court doesn't think it appropriate to reach that issue on the basis of the district court's decision, I'm not going to ask the court to reach it. However, I think it's an easy issue for the court to decide. Because this cause of action did not exists at common law, the jury trial right isn't implicated. Even if the jury trial right were implicated, I think it's quite apparent that the statute doesn't infringe on the right to a trial by jury. It simply delineates the matrix of laws under which a jury trial decision is applied. And I would emphasize the fact that at Charte, the dissenting justices would have found that those statutes violated the Florida Constitution's jury trial guarantee, and the majority opinion expressly rejected that and held that there was no jury trial violation.
You do have language in St. Mary's that seems to be contrary to a Charte.
Well, there's a sentence in Smith, but Smith was from 1987.
No, I'm talking about St. Mary's.
I understand, Your Honor, but the jury trial language is in Smith from 1987. It's a single line. It's dicta. Charte directly held there was no jury trial violation of the jury trial guarantee, and that was in 1993. The St. Mary's case Your Honor is referring to has a language about the Equal Protection Clause, not about the jury trial guarantee. I see that my time is up. If there are no further questions, thank you.
Justice Parenti, you asked, do we have to just accept when the legislature declares overpowering public necessity? In Smith, this court explicitly held that that was not sufficient.
But how about his argument that this looks like it actually helped the situation by lowering premiums, and we could all speculate there might be other reasons.
I think all the evidence is contrary to that. Empirical evidence establishes that there was no litigation crisis. In fact, the number of medical malpractice cases filed continued to decline before the cap, has not changed after. There was no doctor exodus. In fact, Florida continued to enjoy a growth in the number of doctors both in rural areas and non-rural areas in all specialties. There was no impact on insurance premiums. As I said, it's implausible to think that such a narrow number of cases can have that kind of impact. There's no impact on insurance profitability. One of the insurers who had testified in front of the legislature said Florida was its most profitable market. There was no impact on health care costs because, again, medical malpractice accounts for so little of it, and this affects so little of that medical malpractice. The fact is that a litigant's constitutional protections exist regardless of the nature of the insurance industry, its business cycle, and the nature of the healthcare industry. Justice Polston, you asked whether, because of Judge Rogers' ruling, whether the jury trial issue was before you. The 11th Circuit reversed that ruling. The 11th Circuit explicitly held that even though this was a Federal Tort Claims Act case, they wanted to know whether for another litigant the medical malpractice cap would be an unconstitutional violation of the right to jury trial, and they certified that question to you. They indicated that they rejected the United States argument that it doesn't apply to FTCA cases.
Another litigant in this case?
What?
Another litigant in this case?
No. Another litigant generally, because under the FTCA, the United States enjoys only the rights of any other litigant.
Oh, the whole nother level of advisory opinions, huh?
But that is the instructions you've received in answering the question of the 11th Circuit. So because of all those things, because the fact of the matter is that we have plaintiffs who are not receiving the full benefit of the factual finding of what their compensatory injury is. There is no further benefit that flows to them, that their right to trial by jury is violated, that the legislature is essentially making a judicial decision by taking away your authority to remit damages when not shown by the record. We would ask that this court hold the statute unconstitutional.
We thank you both for your arguments. We now move to the fourth and final case on today's docket. Edenfield versus the State of Florida.
May it please the court. Susan Cohen on behalf of Mr. Edenfield. Also seated at council table is David Robbins. Mr. Edenfield was arrested for the offense of driving under the influence on January of 2009. Mr. Edenfield was brought before the court in what would have been his mandated bond hearing because he had no bond previously set on a DUI and had to appear before the court within the 24-hour period mandated by the rules. However, when Mr. Edenfield first walked into the courtroom with the other inmates that had previously been arrested, both felonies and misdemeanors, the first thing that happened was he was handed a form. In the record, they talk about a blue form. Obviously, it's white now. It's about a 7-page form. And it includes a multitude of rights, penalties, mandatory minimum penalties, some boilerplate language regarding the client, the defendant, hearing, understanding, having sufficient time, all the things that the court has advised the defendant of.
Did you say a 7-page form?
It's approximately 7 pages. It's titled Plea of Guilty or No Contest. I believe it, well, can't see on the copy, probably about page 14 in the petitioner's appendix. The form starts out, however, as I indicated, plea of guilty or no contest. And the very first line is, I hereby enter my plea of, and there's a block to mark guilty or no contest. So Mr. Edenfield has provided this form, then he files into the courtroom with the other inmates that have been recently arrested. He then is shown a videotape, which is also included in the record. It's about 13 to 15 minutes of a videotape of rights. It talks about what's going to happen in the felony cases. It talks about what's going to happen in the misdemeanor cases. And there's not a lot of explanation as to which things necessarily apply to whom. It does start out with a discussion about the dangers and disadvantages of proceeding without counsel. Right after it tells the defendants that they have the right to remain silent. Then it proceeds to talk about you also have the right to an attorney and you have the right to represent yourself, but you need to be aware of these specific dangers and disadvantages. The video then proceeds to address the felons, advises the court is going to assume that you want to be represented by the public defender unless you come before the court and tell them otherwise, and you will have already filled out the forms in order to apply for the public defender. And it addresses some of the issues with felons and that when your next court date's going to be, when the court's going to set a bond, and it goes through what we normally would see in a bond hearing, first appearance bond hearing for felony defendant.
Would it be different? You know, your point is that there's an encouragement or assumption you're going to have a lawyer for the felony but not for the misdemeanor. So if the process was that there were two separate videos, you know, one for those that, and if it's county court, just help me, are there felonies in county court?
Well, what it is, it's a bond hearing. So it's everybody is all in a bond hearing together. Right. This is the underlying focus of this proceeding.
If you're being charged with a misdemeanor, here's your video, felony, here's your video. Would it be, I mean, is your argument that they minimized or downplayed the significance of the lawyer? See, I thought you were talking about really more of the dangers of representing yourself. I think there's two separate issues, which is I'm waiving my right to have a lawyer because I'm going to plead guilty.
Yes, ma'am.
Versus I want to represent myself, like we see oftentimes in death cases, you know, where everyone's going, please don't do this, because we know what's going to happen. So is there any, that's what I'm trying to just sort of focus in and make sure on this issue, that we're very clear about what we would want to have happen in the courtroom.
I do believe that's part of it, but the reason that that is significant is because what the issue raised here and what led to the issue, I believe, in the problem with the opinion of the First District Court of Appeal is not necessarily the advisement portion of the Rule 3.111, which requires certain things prior to accepting a waiver of counsel. It requires, one, that the court make a thorough inquiry into a defendant's comprehension of the right to counsel and their capacity to waive. Part of that, the second part of that same section, is an advisement regarding the dangers and disadvantages. So what happens is it dovetails. First you have a video which you have a form which seems to imply you're going to waive all your rights. You're here, you're going to waive all your rights because that's what the form talks about. Then you have a videotape which indicates, okay, for the felons, this is what's going to happen. Next thing they say for the misdemeanors, this is your plea stage. Here's all the pleas. Now, if you do plead not guilty, then we'll talk about counsel, we'll talk about bond, and things of that nature. But the implication is, first of all, you have the right to remain silent, but of course now this is a plea stage and you're going to have to answer. And two, we've already set the stage, if you will, for this is how this goes. This is a misdemeanor. You enter this plea, you waive your right to counsel, we take care of this today, you go home. So we've set the stage. The problem is that there is no subsequent inquiry, thorough inquiry is required.
But I understand what you're saying, but there's no impediment to somebody saying, I'll plead innocent and I want a lawyer.
There is
or I want a lawyer, right?
There is not, other than the fact our Constitution has certain requirements as it has been interpreted by this court and actually all the other district courts of appeal other than this last opinion from the First District Court of Appeal. It has been made very clear that there is no presumption of waiver, either by the entry of a plea of guilty or that there is a presumption of waiver even by saying, I want to represent myself.
Here, there is an express waiver. This is not a question of a presumption. There's an express waiver. And I think you've acknowledged that the advisement of what was being given up in terms of a lawyer was pretty clear.
Yes, sir.
And I don't think there's a real serious question here about the information that was provided to the defendant. The question, it seems to me, that you would focus on is whether it's clear that he understood it.
And that's what I'm talking about in terms of the inquiry, that there was no discussion with the court, between the court and Mr. Edenfield, from which the court could understand and could make a finding on the record as required by law.
But he said he read it and understood it.
Your Honor, he actually said, the judge asked him, did you read through the blue form? Yes, sir. Did you understand the rights you're waiving? Yes, sir. There's two problems with that. First of all, there's all this, the minimum, maximum penalties, all the other things attendant with the entry of a plea. All the other things attendant with your decision about, do I need an attorney to help me with this case, or can I proceed with this on my own? There's also the fact that the court said to him, do you want me to appoint an attorney or do you want to take care of this yourself? Notwithstanding the fact that he had an absolute right to hire his own attorney should he choose to do so, and the rules related to bond hearings specifically provide that a defendant should be advised of the charges against them, and they should be advised that they have the right to make contact with family, counsel, friends, that means will be provided for them to do so, and that the bond rule specifically states if they can't contact an attorney, that somebody at the jail has to help them do that. So you have, this is the situation that you find yourself in. All this is overrun. None of that is addressed, and you have a young man who in less than, depending if you read through the transcript and very slowly, he has, in less than 45 seconds, been brought before the court, advised of the charge against him, waived his right to counsel, and entered a plea of guilty. And he's going to walk out of that courtroom with a criminal conviction that will stay with him for the rest of his life.
Well, but again, I'm trying to understand what would indicate that he didn't understand that. That's exactly what he was doing.
Because the point is, the law requires that the court and the record show that he intelligently...
What should the court have asked?
Something. With all due respect, I know there was a lot of question about age, education. Have sufficient discussion to where determine if he understands.
If it's age and education, legal experience. What answers to those questions will justify the court saying, no, you can't represent yourself. You can't waive your right to an attorney.
Maybe if he answers when asked about his court experience, he would say, well, based on my court experience, I understand since I don't have a lawyer standing here with me, it's too late, so I have to do something else. That might tell the court he doesn't understand. The problem is there's not enough of a back and forth. There's no inquiry from which the court can determine that he can comprehend anything other than a simple statement, yes, sir, no, sir.
Here's the problem that I have, because, again, we got to apply a rule that works with in a felony, might work in a death case. It really seems that your argument is that the procedure as it was set up in Duval County and maybe other counties around the state is one that is an implicit pressure to plead guilty without an attorney and get on with it. It's kind of what we faced with juveniles, that there was excessive pleading, and that the better way to handle that for juveniles was, listen, let's have them consult with an attorney beforehand. So we dealt with that by rule. But I kind of am, following on what Justice Kennedy is saying, I'm not really sure if the form said, what's your age, what's your education, and have you had experience, that's really going to change what you had already said was kind of this thing. If you're a felony, accused of a felony, you're getting your lawyer. But if you are accused of a misdemeanor, you're going to probably be pleading out today and you don't need a lawyer. I mean, that's the real problem, which is so different than the Ferretta situation where somebody is about to start trial and they now go, I want to get rid of my lawyer. That's what these other cases were. And everybody's looking and going, oh my goodness, we're about to pick a jury. This is a case that has 20 witnesses, and this guy all of a sudden wants to fire his lawyer and proceed on his own. So the interests are different. So I don't know how here asking those other questions would really have accomplished what you want to have accomplished if it's still this thing where they're not getting offered a lawyer and the felons are.
I have two responses to that. The first response is, and I guess looking at the way things are handled within this court and even as watching these arguments today, how many times does the court ask a question and the attorney responds and the court justice says, no, that's not what my question was. Had it been a yes or no question, they may have answered yes or no, that they understand or they understand what you're saying. But until they discuss it with you, talk to you, speak to you in more than yes or no responses, you may not have realized as the justice that they didn't understand what you were asking, they didn't understand what you were saying.
So are you saying if it was a 2-minute inquiry, it would have, they're going to get a little bit more, well, tell me a little bit about your job and all this before I'm going to have you plead out today?
It's difficult because it's not in the record and there's no way to put it in the record of this issue. But if you heard the things that people say when they come out of these proceedings and what they think happened and their understanding or total lack of understanding, I think it would help answer that question.
I think I understand what you're saying, but I don't know that having a pro forma checklist is going to change what you are describing as that judges maybe aren't talking in a way that litigants are hearing or the pressures. That's unfortunate, but I'm just not seeing that mandating those four questions is going to solve your problem.
And I'm not suggesting that. My concern and the reason that we're before the court today is because the First District Court of Appeal said that the current version of 3.111 does not require inquiry. Because the pro forma part is the part where you show somebody a video, you hand them a form, you have them sign the form, and then you say, well, you've done all this, so clearly you must understand. What we are suggesting is that the decision of the First District Court of Appeal in this case, where they did by footnote totally ignore the fact that after Bowen was decided, it was in the, I can't remember if it was concurring or dissenting opinion in Bowen, it was pointed out we need some kind of colloquy even for police for courts to use to have a communication with these defendants.
So you're saying it's not the content of the answers they get, is how much discussion they have?
It could be, because it depends. Without the discussion, you don't know what the content of the answers is.
So they just need maybe a time limit? We need to have a 15-minute conversation so I can somehow evaluate you?
Well, if this court determines that 30 seconds is enough to make a decision about somebody knows enough that they are waiving all their rights and they're understanding everything, then I guess that's what the law is. It's just based on all the case law that has preceded and the fact that when you are convicted of a crime, even a misdemeanor, if it's a drug charge, your license is suspended for 2 years. If it's a domestic battery, you may work for Children and Family Services. You can no longer work there anymore. There's all kinds of ramifications of misdemeanor convictions, and there are far more people who it affects. And so it's very easy to say, well, they're just misdemeanor offenses. However, it affects jobs. It affects if you want to be a volunteer at your child's school 10 years later. We were talking earlier today about putting time limits on things. There are far-reaching implications, and while I recognize that many of them are collateral consequences, they are the types of things that an attorney can help you address. They can help you address whether or not it's worth fighting. An attorney can say to you.
We understand, that people really ought to get an attorney to help them evaluate these kinds of situations. But in this particular case, what I'm trying to get is, what more are you contending this judge should have done? They had the form, they did the video. As I read the colloquy that the judge had with the defendant, the judge actually said that, you're entering this plea and you understand that you're giving up your jury rights. He went on, you're not going to be able to call witnesses, those kinds of things. The judge actually says that to the defendant. So what more are you contending, precisely, that the judge should have done?
Well, first of all, before we even got to that point, he's already entered his plea, which means the counsel issue is already over. There's two parts to this. One is under 3.111 in the right to counsel, which this court has repeatedly found per se error if you do not engage in a sufficient inquiry into the right to counsel. So when we look at what we have there, we have the only questions are, do you have a prior arrest? Did you hear the mandatory minimums I told them? Do you need me to repeat them? Of course, do we know if he even knows what that is? But he knows that do we know that what he means, understands what the mandatory minimum means? He may understand what the penalties are, the court has said. And then he says, did you read through that blue form? Well, and do you understand the rights on that blue form?
Did you wish for me to appoint counsel, or do you want to handle the case yourself?
Yes, ma'am, he did. And the problem there is he didn't follow up with any other questions from which he could determine whether or not this young man wanted to hire his own attorney. Maybe he wanted to hire his own attorney, but the court says to him, okay, you've read through all this stuff. You've seen a videotape that has all kinds of information. Some applies to you. Some of it doesn't. We're going to assume you can figure out which applies to you. Then we have this blue form, which gets us to the pro forma blue forms.
But doesn't that go back to the problem I brought out, which is that the misdemeanor video may be implicitly getting someone not to think they need an attorney, whereas the felony is, and it's confusing. But I'm looking at the rule. The rule says that you can't have waived the assistance of counsel until there's been a thorough inquiry into the comprehension and the capacity to make a knowing, intelligent waiver. All I thought you were asking for is that you want to add in and ask about the age, education, and the and prior experience. Is that what you want in the rule?
No, ma'am. There's the model inquiry, which was established by the Conference of Judges and was adopted, when the rule was amended to change some of the language and change it to the current language. And it covers some of those things. But I think more significant is the fact that in some cases it may not matter, but you have a young man in front of you. It may make a difference if they're 18, 19, 21, have no experience in life.
Are you asking the rule be amended?
No, ma'am. I'm asking that the rule be complied with. The rule is fine. The problem is there's no thorough inquiry. It's one thing to advise all day, but the question is
the question is, what rule of law do you want us to adopt? What would we say that must be the judge must do to comply?
The judge must engage in a sufficient inquiry with each defendant regarding waiving the right to counsel. In Young,
again, that doesn't. He asked him. Obviously he's got information there that this person you'd expect the person to be literate. That doesn't seem to be contested here. That this is he said he read it. Okay, so I think it's fair for the judge to conclude that this is a literate person. He said he read it. I don't understand how we're going to come up with something that is necessarily going to solve your problems unless we have a formulaic, detailed recitation that the court has to go through, a series of questions which we mandate. Now, that's an option.
Yes, sir, but I would suggest that we're not asking for that, but what we're saying is that the rule of law, if you will, then, is that inquiry means a discussion with the defendant. It doesn't mean I show you a video, I give you a blue piece of paper, and then I say, okay, I've given you this. Do you understand it now? How do you understand if they understand it?
Whoa.
Yes, sir.
Even if the document itself goes beyond and explains really more, and even if the person responds, yes, I've read that, I know exactly what that says, you're saying that you have to do something further than that.
With due respect, I think all the cases say that.
You don't have to even be respectful. I mean, that's what you're saying.
Yes, sir.
So you have to have the verbal conversation, even though what's done may be more than would go on in a verbal conversation.
We're talking about advisement. It's a two-part process.
I understand.
So, yes, the advisement may be more, but a piece of paper can't inquire and a video can't inquire. Only the court can inquire and have that discussion.
Did the judge here inquire about the material that was given and the video?
He asked if, did you understand those rights? He didn't ask, do you understand you have the right to have an attorney, to hire an attorney as well? You don't have to just take the public defender and represent yourself.
So you're coming back to specific questions that you think must be asked.
It depends on the circumstances. It depends on the defendant in front of you, and I recognize that, and that's where they get into the no magic words. But there has to be some sort of discussion from where the court can say, okay, this person does understand. They may think they understand the English and have absolutely no idea what it means legally. The rule uses the word comprehension.
Okay, does that mean there's got to be a kind of a legal tutorial here?
No, sir, but there has to be a discussion with the defendant before they can say, you can say, okay, they have executed a waiver. He indicated he wanted to represent them.
You're now a minute over. I'll
Yes,
give
sir.
you an additional minute for rebuttal if you want.
Thank you.
May it please the court, Joshua Heller on behalf of the state of Florida. This case actually involves a failure of proof. This case involves a motion to withdraw a plea where the defendant does not allege that his plea was actually involuntary. He does not allege that he entered his plea without an understanding of his rights, including his right to counsel, but only that the trial court's inquiry, i.e. the words of the trial court, were insufficient to inform him of his right to counsel. When offered the opportunity to demonstrate that he did not, he did not demonstrate that he actually did not understand his right to counsel or that he involuntarily waived his right to counsel. In fact, on page 71 of the appendix, he specifically declined to do so, where the court asked, isn't it incumbent upon you to present some evidence that the plea was involuntarily entered, which could be a lack of understanding of your right to counsel? The answer, no, sir. The defendant makes this claim despite the fact that the only record evidence, and I cannot comment on statements that were made that are not in the record, so I'm at a loss with that with regards to what my friend has indicated people say when they come out of proceedings. I can only address what's in the record, and the record evidence is the defendant was provided with detailed information regarding his right to counsel and his right to self-representation in a 13 to 15-minute video. He was provided a blue form explaining each of his rights, including his right to counsel at the plea stage and beyond, and he was individually inquired by the trial judge as to his understanding of his rights and signed a waiver of counsel form, all regarding his knowing and voluntary decision to represent himself.
Can I ask a question on the basis we're here? We're here on...
certiorari.
Oh, no, we're not here. The jurisdictional basis.
Correct.
We're here on conflict. But this case came up from the first district as from the county court to the circuit court that affirmed, and then the first district is really, they're reviewing it under cert, so they're just looking to see if there is a departure from the essential requirements of law.
Resulting in a miscarriage of justice.
Right. So I don't see how case would be a very good vehicle assuming there's even a point here, which I appreciate the bigger picture of whether we're just having, mass justice that's not really justice, but to why we should not discharge jurisdiction in this case.
Your Honor, the state agrees with you completely. In fact,
I want that.
I want to point out. I mean, I want to address the issue, but I don't disagree with you at all. I think that's exactly correct. And I didn't ask for you to consider the case.
Well, it's not unusual for respondents to agree that we should discharge.
Yeah, I imagine not, Your Honor.
Fairly common.
I mean, but it does seem to me, the reason, and I understand there may have to be a one-size-fits-all rule, but the bottom line is that judges who are having, the cases from the second district involved, first of all, an older version of the rule, but it also involved defendants who already had an attorney.
And respectfully, they don't cite the appropriate U.S. Supreme Court precedent, Your Honor. This is the only case to cite Iowa versus Tovar, and my friend has talked about all the cases, yet there's been no discussion of what the United States Supreme Court has said with regards to this. And respectfully, which was in 2004, respectfully, your rules actually act in harmony with what they said. In Iowa versus Tovar, the United States Supreme Court held that a plea is knowing and voluntary entered by an uncounseled defendant if there are three elements present. One, the defendant is informed of the charge. Two, the defendant is informed that he has a right to counsel at the plea. And three, he is informed of the possible penalties attenuate to his conviction. As we move away from the trial, the dangers and disadvantages, according to the United States Supreme Court, are more evident. Here, that is what the dangers are. Now, respectfully, the court in this circumstance went far beyond that. And I would respectfully suggest, I know that we've talked about thorough inquiry, but I think that the thorough inquiry needs to be considered in harmony with what the United States Supreme Court has said is the substance that must be obtained from the defendant, the information that must be obtained. In the individual inquiry alone, where the trial judge is speaking directly to the defendant, all three of Tovar's elements are met. Mr. Edenfield, you were charged with driving under the influence. That's the awareness of the charge. Same question to you as others. You're not required to respond, but if you do, you must be truthful. Do you have any prior convictions for DUI? No, sir. All right. You appear to fall within the same minimum mandatories. Do you want me to go back through them with you? No, sir. There's our awareness of the possible sentences. Do you wish for me to appoint counsel, or do you wish to handle the case yourself? I'll do it myself. There's our element 2 from Tovar. He is aware of the right to counsel at the plea. That's what the inquiry is supposed to be, according to the United States Supreme Court, and that's what the essential requirements of law are. Furthermore, this court has indicated at least 3 times by my count, including extremely recently in McCrae, it is not the words of the trial court that matter. That is not the critical question, and that's exactly what the argument is here. The question is, what is the understanding of the defendant? And here, where the defendant was provided a 3170L hearing to demonstrate that he lacked some type of understanding, that he had a knowing and involuntary plea for some reason, including his lack of understanding of the right to counsel, or any number of a panoply of reasons, the defendant said nothing. No evidence was presented at all. In this case is a failure of proof. I also want to address, if I may, the reference to the fundamental error that I've seen in numerous occasions by my friend in brief. And what I want to point out with regards to that is the cases that are being relied on, and I think improperly by the DCAs. Justice Quince, you actually wrote one of them. It was TC and BP, and I apologize for not knowing which one because I'm not really good with initials. But in that case, you expressly discussed that in juvenile circumstances, it's different. Juveniles are different. We have an extra concern when it comes to the right to counsel for a juvenile. And as a result of those cases in 2005 and 2008, you amended your rules specifically referencing those cases so as to not prohibit a juvenile from waiving the right to counsel, but simply requiring that they have counsel to discuss with them whether or not they should waive. That's a specific concern that, Justice Lewis, you discussed at length in the rule amendments that related to juveniles. But when we can't take that and move it outside the concept of a juvenile. It becomes contradictory. Fundamental error is error that is inherently harmful. However, this court, as I indicated, has said it's not the words of the trial court that matter. That's not the inquiry. It's the understanding of the defendant. So if the understanding of the defendant is key, if the understanding of the defendant is what we're looking at, then the words of the trial court not mattering, how can those be inherently harmful if the defendant actually has an understanding of his rights? Finally, the last point that I wanted to reiterate is we are here, I realize, on conflict related to cases that are not citing Tovar, that are referencing old law of a pre-Bowen amendment to the rule. However, we look to the essential requirements of law, and I think that the court needs to look at, this is not a case to make law based on its posture. It is a case where we have to look at what the essential requirements of law are, what the United States Supreme Court said in Tovar is required, and what the and how that applies with regards to the thorough inquiry.
Do you think that the rule definitely requires a thorough inquiry? Is it the argument is that you put videotapes on, they're in a room, they just been, maybe he was in jail overnight, signs a form, that the thorough inquiry that was contemplated, as I guess is in the inquiry of the, model inquiry of the Conference of Circuit Judges, is that the inquiry is between the judge and the defendant. And here, the only inquiry is after he signed those things, he says, okay, you were charged with driving under the influence. Same question to you as the others. You're not required to respond if you do, and then starts asking questions. Now, is that after he had pled guilty, or is that the inquiry about waiving counsel?
Well, he actually pled no contest, Your Honor, and it was, but it was after that.
Where's the inquiry as to waiving counsel?
Your Honor, the defendant was discussed at length with regards to the video.
No.
I understand.
I said
he
had
wrote,
a video.
He actually did.
Where was the thorough inquiry with Mr. Edenfield?
Mr. Edenfield was asked, do you wish for me to appoint counsel, or do you wish to handle the case yourself?
I'll do it myself.
I'll do it myself. That's correct.
And that's the end of the thorough inquiry.
Your Honor, that's what the substantive law of what an inquiry requires.
What would be if we, in a case where someone already had a lawyer, and we know there's no magic words, but we would approve that, let's see, you have counsel, I've told you there's risks, you'll do it yourself. You're going to do it yourself.
Your Honor.
How does the person, I'm now that I look at exactly what was asked, how could that possibly be a thorough inquiry?
Well, Your Honor, in Tovar itself, the question was to Mr. Tovar. Mr. Tovar appears without counsel, and I see, Mr. Tovar, that you waived application for a court-appointed attorney.
Are we talking now about the U.S. Supreme Court case?
Yes, Your Honor.
All right, I'm talking about our rule requires a thorough inquiry.
Your rule effectuates the constitutional right.
Well, we may be wanting more rights than the Constitution. You think a thorough inquiry is saying, do you wish for me to appoint counsel? Do you wish to handle it myself? I'll do it myself.
No, Your Honor. What I'm suggesting to you is that thorough inquiry is that the defendant has provided extraordinary amounts of information regarding his right. He's including the video, including
do we know?
Wasn't he asked if he had read it and understood it?
Yes, he did, Your Honor, and yes, he was.
So that's part of the inquiry.
That's correct. Yes, it is, Your Honor. And he was. So that information is imputed, and the defendant, again, has never indicated that he did not actually understand that right at any point in this case.
We had a case this week where people are asked in a voir dire, have you ever been accused of a crime, and they don't answer. There's the unfortunate dynamics in a courtroom, and we see it all the time about what judges are taught about how do you engage in careful listening, because people are intimidated in a courtroom setting. I'm just a little hesitant to say, and this is why, maybe the answer is just discharge in this case if it's a failure of proof, but that this would be equivalent to a thorough inquiry. under the rule. Now, it may be that it's not doesn't meet the other requirements of, because you said that it was a withdrawal of plea under L, which we're about to maybe delete, but
it would be 3850 in that circumstance. Yeah.
It would be 3850 after the fact, but wouldn't it be better to make sure that at least there is on the issue of self-representation, that there's more? We certainly wouldn't condone it in a death case, I guess is what I'm thinking. We wouldn't say, well, you watched the video out there and you did, so you understand everything. So, I mean, and again, the circumstances matter. Maybe it does. Should a misdemeanor inquiry be different than a felony inquiry and different from a death case?
I think I can answer your question by addressing, I think, what is the underlying premise, which is that you indicated that thorough inquiry seems to imply the model inquiry, which you've also indicated in prior case law is not actually part of the rule. And if you look at the model inquiry is not just about asking questions. The model inquiry is about providing information. In this particular circumstance, the information is provided at length to the defendant. The thorough inquiry, I think the use of the phrase, okay, we're going to talk about the advisement versus the inquiry is a bit of a false dichotomy. The information provided, the questions in that model inquiry do not serve solely for the purpose of asking questions. They provide information. And here the information is provided at length in the video presentation. It's provided to the defendant individually. The defendant indicated that he did not want counsel appointed and that he had read the rights that were involved in that particular information. And he also, along with others, indicated that he understood the rights as set forth, saw the video and understood the rights as set forth in the video. So I think that the underlying premise of the question, that the thorough inquiry necessarily or seems to imply the model inquiry, is belied by this court's decision, for example, in McCrae. And does that answer your question, Justice Barriente? Accordingly, for the reasons set forth here in light of the failure of proof of defendant at every stage of this proceeding, and because the petitioner has utterly failed to demonstrate that his waiver of counsel and plea was unknowing or involuntary, the circuit court did not depart from the essential requirements of law as set forth in Tovar, resulting in a miscarriage of justice by affirming the county court's decision to deny petitioner's motion to withdraw his plea. The decision of the First District is properly affirmed.
May it please the court. Tovar is not binding on this court. This court has made clear in the past, and as recently as a couple years ago in Kelly, that is the floor. The state constitution dictates the interpretation of 3.111, and this court has stated that is the genesis of this rule, not the federal constitution. And the last thing that the court said in Tovar is other courts can and have provided additional requirements or different rules and cite our rule. So this is not a case that is ruled by the federal standards. It's the state standards.
Then your position basically would be that thorough inquiry, at the time the judge said, do you want me to appoint a lawyer for you, or do you want to do this yourself? And even though he said yes, the judge should have then followed up with, that the dangers of representing yourself again?
No, ma'am, but the court could certainly say, did you see on the videotape, among all the other information, maybe not including that, but that the dangers and disadvantages of representing yourself? Do you understand that although I've asked you if you're waiving your right to be appointed an attorney, you still have the right to hire an attorney? Some sort of discussion from which a court can determine. If you look at plea colloquies, which you have to show prejudice, there's a lot more you have to show. There's all these requirements for the waiver of counsel, which is far more significant.
Let's look at the motion to withdraw plea.
Yes, sir.
And what happened in that proceeding. I mean, is it your position that it really doesn't matter whether the defendant understood everything perfectly well? That if he understood what rights he was giving up, and that's just the choice he made that day, with full knowledge, with his eyes wide open to what he was getting into, that's really irrelevant. That what we have to look at only is what was on the record. And if we can't see on the record something that meets whatever standard you would have us articulate, then then he gets out of the plea?
I think there's two answers to that. First of all, if he were to come forward and testify, I know you told me this, that, and the other, but I didn't understand. The state's response is, of course, we showed you a video, we gave you a blue form. Well, that rebuts what you're saying. End of story. There is effectively no review because then it's a credibility concern, which may be why counsel issues have been determined to be fundamental.
Well, so your answer is that it depends entirely on what's on the record.
Yes, sir, because
and
that's
when you go to the hearing on the withdrawal of the plea, it's just there to talk about what's already on the record. It's not actually to focus on the understanding of the defendant.
On this issue alone, had there been a discussion with the court, and then the defendant comes back and says, I know it looks like I understood, but I didn't really, that we had this discussion, and then it's because that's a different standard. If you have that discussion, then it's the court's discretion, but that's different than when the record, and that's what's been consistently found in the decisions of the district courts and this court, is what is on the record. The court must state and establish on the record how and why it is finding that the defendant is knowingly and intelligently, with full comprehension, which is the language used in the rule, waiving their right to counsel.
All right, you've gone well
Yes,
over
sir.
here. We thank you both for your arguments. And that's the last case today and this week, so the court now stands adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.